Morning, gentlemen. How are you? So we're gonna start. I don't think there's a ton to go over anyway, from my perspective, but um, if any of you gentlemen would like to join us up at the mic and just to discuss the issue in general and also the amendment that we have before us, that'd be great. I don't think this is a controversial bill, but it seems pretty straightforward. Um, so what we're looking at in front of us is a, a new definition in statute for stationware, because we don't have that right now, correct? And we want to be able to do that so we can differentiate between PFAS, between the personal protective wear and the stationware,
Correct.
correct? So that we can work towards um, firefighters not having to wear PFAS-laden stuff until such time that hopefully we get new equipment that isn't laden with that, but also doesn't burn. I'm understanding so far.
Yes.
All right, so Fred, for your benefit, the amendment to the amendment that I have in front of me, or at least a proposal of one, I haven't brought it to OLS yet. If you look at page 2, line 9, we've adjusted the safe alternative to current firefighting personal protective equipment, if it's designed, from the requirement shall be required to a should, a preference being given to it. So if that new equipment comes on the marketplace, fire stations aren't required to pick it up, but they are encouraged to pick it up as they're going through their regular replacement that they would normally do, correct?
Yeah. So gear replacement by manufacturer date is good for 10 years before it needs to be replaced. And what we were trying to avoid was to put municipalities in a position where there was some sort of unfunded mandate to say you must purchase whatever gear is on the market that meets these requirements. Instead, we think that there's enough. We're leaning on the manufacturing industry enough from an international perspective to start having these manufacturers develop this gear over time. So as you mentioned, it would just be encouraged at that point. But I do believe nationally at some point there's going to be a drop dead date on when you can have gear with known PFAS manufactured into it. So trying to get ahead of it.
Yeah, and assuming, Peter, how are you? Now we're official.
Yeah.
Assuming, of course, that they are able to develop gear that doesn't use PFAS in it, correct? Because it's still the safest thing we have on the market.
Correct. Yeah, it's still the safest for what we call an IDLH, which is immediate danger to life and health. There is, I don't want to give you the manufacturer name because I don't remember if I'm 100% correct on it. But there is one manufacturer right now who's saying that they'll have this developed soon. I do know that we have one fire department, and it happens to be here in Concord, that is looking to move forward with the purchasing of this gear. So it is on, I wouldn't say the immediate horizon, but it's coming close.
Okay. Backing up just a sec to line 1, the manufacturer or person selling firefighting personal protective equipment and the purchaser of the equipment shall retain the notice of the procurement files for at least 3 years from the date of the transaction. First off, that's the notification of whether or not there are PFASs in the material. What's the purpose of the 3-year mark?
So that is what's in current law.
That's just in the current
So we're not proposing that we would change that. What we're looking to change is right now by law, if the gear has PFAS in it, the manufacturer has to send a letter.
Okay.
And that letter goes in the personnel file indefinitely. It then remains in the procurement files for the department for 3 years. I don't know why they landed on that. That was before my time. But what we're trying to do is, because the manufacturing industry is, many of them are saying, no, our gear does not have PFAS in it. We want to change the law to make sure that that notification comes regardless of what the claim is. If they say the gear has no PFAS in it, we also want that on file.
Yeah.
And then we want a copy of the same to be provided to the employee, which is not a current under current law right now. We want the physical employee to have a copy of that letter.
Yeah, so they know what they're wearing.
Yeah.
Yeah. Okay, and then, oh, Peter.
Thanks.
Yeah.
So Brian, what kind of pushback are you getting from the manufacturers on? I mean, I totally get the idea that you want that in there because if they need to put that stuff in there to make the gear work, I'd say if. Then, and the firefighter has to wear that gear because otherwise he's gonna get killed in the fire or severely injured and so forth. So it's a trade-off, but fact has to be clear that he's wearing that. It's kind of like you're taking the risk by being a firefighter, lots of risk. But this is one of them that you should at least have a record of because otherwise, I mean, it's just not right not to have the clarity. And if the manufacturers say it's not in there, then that should be, it's a claim, right?
Yeah. Thank you, Representative, for the question. We want to make sure that that manufacturer is on record, stating it does or it does not have it in it. I will say I'm unaware of it happening here in New Hampshire as of yet, but there has been, this is an international issue, and there has been a number of lawsuits that are now currently being worked through with manufacturers saying our gear does not have PFAS in it, and scientists saying that it does in fact have it in there. So the International Association of Firefighters is fighting against the National Fire Protection Agency as well as gear manufacturers. And that's what, when I say that our organization is leaning on these manufacturers to make these changes, that's the intended effect here, is just to put pressure from a New Hampshire perspective to say that we're not going to do this anymore.
We're not gonna do what?
We're not going to put our firefighters in a position where they are known to be exposed to PFAS chemicals.
Well, if there's a viable, if there's an alternative, I remember we had a bill maybe 10 years ago, right? It was a big issue about firefighting foams and so forth and so on. And Adam, you probably remember that there was an alternative. Maybe it wasn't completely harmless, but it was a lot better than, and that bill passed, right? You remember, Adam?
Yeah, so that's exactly it right now, is there is no alternative. And it is been proven that the gear with PFAS in it, it's almost a roll of the dice whether or not you're going to get cancer. But certainly if you were to go into a fire without this gear on, you would not survive. So that's the trade-off. When there becomes an alternative, then it becomes harder and harder for either a municipality or a manufacturer to not provide that alternative. And that's what we're trying to accomplish.
So, and Mr. Chairman, so you're
Yes.
okay with that?
I am. Yeah, no, that sounds good. Any other, Fred, anything up until this point?
There is no alternative here right now?
Correct. They have, there are certain manufacturers that have been able to identify, firefighter turnout gear is comprised of 3 layers. That's how it's constructed. Some of those layers, they've been able to identify alternatives that do not have PFAS in it. What they're struggling with is to find a safe alternative for the water and oil repellent. And that's essentially that's what they're using the PFAS for, as a durable water and oil repellent, so that you don't go into a fire and get your skin wet to the point that you burn kind of from the inside of your gear out. So, and that's the key word here, or the key words, is safe alternative. We're not looking to identify turnout gear that has no PFAS in it, but is not going to protect us within a fire either. And that's why we drafted it the way we did, was we wanted to make sure that this alternative is proven to be safe. We're not just going to take any gear off the street without making sure it's tested and proven first.
And once again, it's not required anyway. It's just
Correct.
strongly encouraged in the language of the bill or the new. So, Peter, that would be line 9 and 10. the proposed amendment that we're talking about right now would strike shall be required and is replaced by should give preference to an alternative as part of the existing personal protective equipment.
9 and 10, you said?
Yeah, on page two.
On page
Two.
2,
Yeah. You'll see it. It's in lighter on yours, but
shall be required. So
Yep.
We're striking that.
and changing it to
Shall be
should.
required is should.
Yep, and that's for, as Brian was saying, maybe just before you came in, not downshifting costs to municipalities into some smaller fire departments. If, for example, a safer alternative came out, but it was 2 or 3 times the expense because of the manufacturing type, they didn't want to push that onto a smaller fire department. They can have that conversation on whether to give their guys cancer in their own town, I suppose.
Yeah.
Or how often potentially they have to put that stuff
Sure.
on, if it's once every, 9 months, or I don't know what happens in the volunteer departments.
It's kind of all over the map.
Yeah.
Okay.
So that would be a conversation that could be had. Any other questions from the committee though, up through line 11?
I apologize.
Yeah.
Were there any issues before I came in?
No, I don't think so. Everything's, the major differences between the original bill and the amendment you were here for.
Okay.
So we could talk about the underlying bill, but
Mhm.
let's see. So moving on then, line 12. I only had one question on lines 12 through 16. It says, until such time that a safe alternative is provided to the employee, fire department shall have in place a policy that limits the unnecessary exposure to firefighting personnel protective equipment. Nothing in this subsection shall refute that it remains the best practice for firefighting personal protective equipment to be worn while operating in an environment that poses an immediate danger to life or health. My only question, Mr. Rill, on that is, obviously this would put pressure to give preference to not wearing the equipment as much as humanly possible. Are you at all concerned that this opens up the risk that a fire chief will go too far and not have his men wear it in a toss-up situation and then somebody ends up getting injured?
Sure. I appreciate the question. I don't believe so. And in fact, we've been working closely with the fire chiefs on this issue to make sure that we get it right, because we don't want, it's not our intent to put fire chiefs in a position where they can't lead and do their job. So one of the things that came up was, for instance, training. What about putting our firefighters in gear while we're training? Is that, are we going to get in trouble for that? Quite frankly, that happens now with PFAS knowingly in the gear, and it's not created an issue here in New Hampshire. Secondly, we chose our words carefully in using unnecessary exposure. If a fire chief determines that exposure, quote unquote, to be necessary, that gets them off the hook for any wrongdoing. So the point here is each individual fire chief would have the autonomy to look at their policies from within. Many policies are just created by fire chiefs. Many have a labor management component where they work together to develop policies. But essentially, they would develop a policy, put it in place that says, for instance, where I work in Portsmouth, you will wear your gear in an IDLH environment, as we spoke of earlier, or for any vehicle extrication or relevant training or anything of that nature. All this would force departments to create their policies that determine what is necessary and what is not.
And what? Oh, go ahead. No, go ahead.
What's IDLH?
Immediately dangerous to life and health.
I get it.
So, what are the ramifications if these policies are put in place and then somebody questions and wins that the fact that it wasn't necessary and they required them to wear it, or vice versa, and injury or disease occurs arguably for that reason?
Sure.
Like, can they sue? Can they, like, what's the...
We have not put anything in place that would determine that, but what I can say is determining whether the wearing of turnout gear is necessary or unnecessary, to my knowledge across the board, is subjective in nature. Because, for instance, we may tell someone they have to wear their firefighting turnout gear to do vehicle extrication, but another department may have specialized gear that they wear to do vehicle extrication. So really, it would be extremely difficult to identify whether or not you put someone in gear and they said that was unnecessary exposure. Well, take training, for instance. A fire chief might determine that we need to crawl around and do search and rescue training. We need to do that with our gear on. So he's determined that, or she has determined that to be necessary, and necessary potential exposure. And if it's unnecessary, for instance, what this is trying to curtail is those firefighters going out and doing traffic details, or standing by at a power line down and they're wearing their turnout coat. This is what that's trying to curtail.
Yeah, but there are no civil or criminal.
We have not put anything in place for that. I unfortunately,
I'm more
not-
comfortable if it's not there. I'm just
yeah.
saying that it's-
Not having spoken with any civil attorneys on this, I don't know if there's exposure there, but
But it
that's
doesn't look
certainly
like
not the
it
intent.
doesn't look like there is any in statute
Yeah.
unless it was somewhere around. I can go back and look at 154A8 in that section and just see if there's anything.
Sure.
But
So
it's certainly not in the amendment or the original bill as
Yeah.
proposed. So
and I could also speak to the policy that we're trying to make sure is in there. To some degree, that already exists under the presumptive cancer law as well. In order for firefighters to get the benefit of presumptive, among other things, their department needs to have a policy in place that follows best practices as it's defined by the New Hampshire Fire Academy. So that something very similar to that already exists. We're just trying to build upon that.
okay. Any other questions or comments?
You're gonna check. you said
Yeah,
you-
I'll check on that. Yep,
Okay, good.
and make sure
I
that
mean,
nothing's
I
ever-
get it. I mean, you could certainly have a situation like a football player, for example, where you say, okay, we're gonna do a run-through in ordinary clothing, right? But you realize that in a game, when you got equipment on, you can't do that with equipment on. I mean, a helmet protects you, but it also restricts your visibility. You can catch the ball, you could turn your head all the way around, but you can't do that with a helmet on.
Sure. And that's why,
So having a written stated policy, I get it.
Yeah.
We want to have that in place, but otherwise, then it becomes arbitrary.
and again, the policy is going to define what is necessary and what is not. That's the key here.
But
Is
like
the-
you said, if you're standing around waiting for something and you're wearing that gear,
Right.
that doesn't strike me as reasonable.
Fred, any thoughts? You good? Okay. So moving on then, this is where the major differentiation between the original bill and this comes in, line 17 through line 22. Beginning January 1st, 2025, fire departments shall not provide as an option the purchasing of firefighting station wear that contains intentionally added PFAS. Before it was just that you couldn't wear 'em, period. With the fire-resistant chemicals which contain fluorine, chlorine, bromine, lead, or antimony. And beginning July 1st, 2025, so pushing it out 6 months, fire departments shall not provide as an option the wearing of the same. Manufacturers of firefighting station wear shall provide fire departments with safer alternatives should they exist. I'm assuming that the reason for pushing out the wearing is it would give one purchasing cycle for people to make the transition. Is that the idea behind that?
Correct. Yeah, this came up when during the public hearing, and I believe it was Representative Lakis who brought up his concerns. While he appreciated we were trying to avoid any unfunded mandate, he saw the potential here with the prohibition of purchasing and the prohibition of wearing occurring on the very same day. So the idea here was if this gets signed into law, it would be signed in by July 1 of this year, which would get 1 full year for an employee to stop wearing that station wear. And the employer provides new uniforms for them to wear or a uniform allowance so that they can purchase non-PFAS station wear.
And when does that usually come out? January 1st?
When
For
does
most of the allowance for
it
purchasing?
varies. I wouldn't say it's a hard and fast rule that it's January 1. In fact, ours I think begins on July 1, and it goes with the fiscal year. But in I don't want to say all cases because I don't know that for sure, but I would say I believe that in all cases there is a uniform allowance that occurs annually or purchasing of uniforms that occurs annually. So there should be no reason why this can't this can't be taken care of then. And I do want to point out that it's simply stating that the employer cannot provide as an option the wearing of that. So essentially that shifts the burden to the employee to say, because most departments have uniform options that they can wear, it just removes that as an option.
So in the example that you just gave, though, of July 1st, because we would be coming up on that within the next few months, being when somebody gets their allowance, if this wasn't clearly communicated before that time for some reason, and they went out and bought all their station wear, they arguably wouldn't be getting a new allowance until July 1st of the following year, which is your deadline for no longer being able to wear that equipment, correct?
Correct.
So that would put them in a situation of at least knowing a year ahead of time, but maybe not quite having enough time to pick up the equipment. Would that be accurate?
What I can tell you is if you were to, and this is just strictly for uniform shirts and pants.
Right.
If I were to order a pair of uniform pants or a uniform shirt, I get it in a week. It's not difficult to find. There are uniform apparel companies all around us that it's readily available. So, and not only that, but it's not like firefighter turnout gear where it costs $5,000 to outfit someone. You're talking about a pair of pants for 40 or 50 bucks and a shirt for 20. So, if the dates are off by a week or two, one way or the other, I don't think it's going to create a whole lot of anxiety.
Okay. Any comments or questions from the rest of the committee?
We're getting there.
Okay. Anything else that anybody else wanted to state? I'm assuming everybody else is in support of the proposed changes. Or you guys usually chat about that.
Yeah.
So.
Yeah.
Okay.
Yeah, we've worked together on this to make sure that we get it right because again, we have when we talk about the relationship between labor and management, sometimes we're heading towards the same goal, but we just get there differently. So we wanted, and that's the reason for some of these changes or proposed changes to the language is to make sure that we get it right to satisfy all the groups involved.
Okay, perfect. For the committee, anybody philosophically opposed to anything that we've heard in the... All right. So here's my proposal then. I will look into civil and criminal stuff just to make sure. I highly doubt anything's in there. I just want to double check and make sure before we go running this through.
And you're gonna check that one place we talked about,
Yep.
double check.
Yeah, I'll double check that just to make sure that there's no conflict. Otherwise, philosophically, it sounds like we're all probably on the same page. This seems very reasonable.
No,
I will get the amendment printed into an official form, and then the next time we meet as a subcommittee to look at some of our other ones, we'll just vote on this one and send it to the full committee.
who's missing? Jason is missing. and-
Jason and Steve Boyd. We haven't had Steve here yet.
Yeah, we haven't been Steve at all. Okay.
So does that sound reasonable or any concerns?
Reasonable to me.
All right. So yeah. So barring that, guys, I think this will probably sail. I think I don't think you'll see any. I don't think any major resistance to it.
Yeah,
so-
I feel like it was pretty widely supported early on. It was just that date change that
Yep.
needed to be modified. So
Yep. All right. Well,
Great. Thank you.
having said that, I'll close the work session for the subcommittee on 1352, and we'll pick it back up the next time that we meet. Thanks.
Sounds like an evening.
All right, good morning, everybody. I want to thank the committee for lasting through a major load of bills. Today is our last hearing on our original bills. We should be getting many of these out of the way. We have next week off unless your subcommittee decides to meet, but that's between you and the rest of you. And if we get any second committee bills, I plan to hear them on Wednesday, the 6th, with an exec session on any bills that have come out of subcommittee afterward. So reserve that day. Other than that, March is entire, and the 13th is the planned date for all the rest of our bills. And beyond that, the subcommittees will be working all through March. So, all right.
Madam Chair,
Yes,
so 7th, we don't have session then. You're scheduling the exec session.
I don't know. I have heard rumors both that we will and that we won't. I think it depends on how many bills the other committees get out this week. At least one committee is meeting today to exec. And education had a whole slew of them yesterday. So they're probably going, we're not going to be able to get away with from all those 10-10 votes and repetitive debates in education. So, all right. House Bill 1328. Is there anybody here who cares about it?
Well, do you want me to introduce this?
Well, Representative Schmidt's standing up. Let him introduce it.
I just saw pro.
What? I don't care either way. That's my question. All right, so we're opening the public hearing on House Bill 1328, and Representative Schmidt is here to introduce it.
Madam Chair, happy to introduce Representative Prue's bill, House Bill 1328, relative to public safety providers defined as essential services. And it's a very brief bill, as you can all see. Just one line, basically, first responders are essential services providers. So I won't take any questions, but that speaks for itself. Thank you.
Thank you, Representative Schmidt. All right. Is there anyone else who wishes to testify on House Bill 1328? Seeing none, I'll close the public hearing and go into executive session. Representative Grota, you had a motion?
I do, Madam Chair, I move auto pass on House Bill 1328.
Okay, Pat, do you wish to speak to your motion?
Yes, thank you. I think by defining emergency first responders to this, it gives them the same status that other first responders have, and I think it's rather self-evident, but if it's something that people want to put into statute, I'll support that.
Okay, thank you. Representative Gould?
No additional comments. I think Representative Grota said it all.
All right. Any Representative Delekas?
It's like, I mean, not having heard anything about this, what are the consequences or the effects of naming them as essential service providers? What do they get something or other?
I believe it's something in the emergency management.
Well, it gives them the same authority in law as if they're considered essential workers, just like public service, fire departments, law enforcement, and this can give them, for example, if an emergency situation should it come up, then they are considered part of the team, and also I believe that we do have other things in statutes that this type of management, emergency management has as far as access to counseling if they need it, that type of thing.
Ah, that's
I
very
was
true.
just wondering, yeah, if anybody else has any more information. I'm not opposed to this. I'm just wondering what I'm voting on.
It just puts them in a category
Yeah.
that they have the same job-related pressures and status that the other people who are involved with emergency response have.
Okay, thank you.
I think that's probably the genesis is because Representative Prue is involved in that counseling team. Representative Simon.
Thank you, Madam Chair. Also not opposed to this on principle at all. I mean, it seems reasonable. Just looked up the statute that's referenced and literally are just putting first responders or essential service providers at the end of it. Are are essential service providers typically, is that typically in statute that we put that? I mean, it is. Okay. I just don't know where else that is located.
Sorry, yes.
Yes, Representative Mangiaputi and then Brown.
Thank you, Madam Chair. Just a quick question. First responders include police, fire, and are the emergency room physicians, if it's in a disaster, would that become a first responders?
That's in a
First
different statute.
responders are already defined in statute, as you can see in the bill. It's emergency public safety, fire, law enforcement, telecommunications or dispatcher, emergency response, emergency medical services, emergency management, public health, clinical care, public works, and other skilled support personnel. So that the backhoe operator that's helping out at an accident could be considered. Anyone else?
Yep.
Representative Brown, yes, thank you,
Thank
sorry.
you, Madam Chair. So looking back at the governor's emergency order, one of them, it does say that industry sectors that provide essential services, et cetera, those deemed essential will continue to have the ability to cross state borders for work related to travel and transporting products, et cetera. And I know that from my history, we've talked about this at town, if you can identify essential workers, then you know the people that you can tell to stay home in an emergency that you don't need to have come in and unnecessarily traveling. And there's also, certainly FEMA has a whole list of, they don't call it essential workers, and I wish I could remember what they, but they have 12 categories that define in an emergency who should be working and who should be staying home.
Ah, okay. I'm not surprised that FEMA divides them into 12 categories rather than 2 or 3, but that's the federal government for you. Or anyone else? Yeah, I'd like to say I'm not sure this is entirely necessary, but it certainly seems innocuous. Okay, anyone else? All right. The clerk can call the roll. Oh, excuse me, Representative Simon, you were just queuing up.
I don't know. I was going to say, if there is such a thing as an essential service provider, whether it's innocuous or not, it just seems to me like that these people would fit into that category. If such a thing is a thing, then I don't know who else would fit into it if not these people.
Exactly. Yes, Representative Brown.
Madam Chair, and it might also have something to do with FEMA reimbursement or of those things of that nature too.
Yes, we don't know enough about FEMA reimbursement to really be smart about it. You are so correct, Representative Schmidt. All right, FEMA, and other things. All right, anyone else? In that case, we do have a quorum. The motion is ought to pass by Representative Grota, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Dolan.
Yes.
The clerk votes yes. Representative Boyd. Yes. Representative Brown.
Yes.
Representative Grota.
Yes.
Representative, keeps cutting out. Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiaputi.
Yes.
And the chair.
Yes.
16 yea, 0 nay.
All right. Is there any objection to consent? The motion passes 16-0. Not seeing any, we will put this one on consent. And we have a short break until 10:30.
Being 10:30, I would like to call the public hearing for 1622 into order and welcome the esteemed Representative Carol McGuire to introduce the bill.
Thank you, Mr. Chair and members of the committee. House Bill 1622 is, dare I say it, a housekeeping bill to clean up some of the issues in the administrating rulemaking process, and it is a request of the office. They will be able to explain most of the details. I will point out the last two sections, number 7 and 8, which are the ones I'm most proud of. Section 7 says that if an agency levies fines after a rule expires or assessed fees from an expired rules, then the agency shall refund all fines and fees. That is, that has been the rule in OPLC for the most part. Other agencies have insisted they didn't collect any. But since an expired rule is not valid, then they can't collect fees and fines that are only in the rule. So this will say, give it back. Section 8 says that if a rule is expired when they're proposing readoption, then they have to provide a written report on what happened while the rule was expired. If we've had one this year where it was expired for a week and a half, and they basically said we just didn't do anything on that for the week and a half. Another one had been expired for 12 years, and it took a little more effort for them to explain what they'd done. But this way, each agency that has an expired rule has to think about it and report it prior to the GELCAR meeting. So I think those are important. And the rest of it is, as I said, minor cleanup. I also am presenting a germane amendment, 0306H, which I've distributed. This is an addition, also at the request of the GELCAR staff, mostly on timing. So if you want to talk about the details, the GELCAR staff is here ready to answer your questions. If you want to talk principles, I'm glad to.
Thank you. Any questions? Seeing none, thank you for your
Thank you.
testimony. Michael Morrell, OLS rules.
Good morning. I'm Michael Morrell. I'm the Director of the Administrative Rules Unit within the Office of Legislative Services. I can answer questions, or I can briefly go through the bill, whatever the committee would like.
Yes, Representative Likas.
Would be helpful to just briefly go through the changes in the bill and the amendment as well.
I agree. If you wouldn't mind, thank you.
The first two sections of the original bill deal with changes regarding the Office of Professional Licensure and Certification, OPLC. One, it talks about records of the boards. Right now, it appears that the record-keeping requirements varies significantly between the boards. Some, I think, do not even mention it. So this would simply require the boards to specifically, within their rules, specify a date for perhaps 3 years for record retention. It could be whatever they wanted.
the second portion, right now it says licenses shall be valid for 2 years. We thought this should also include initial licenses, registrations, certifications, and renewals, just to be clear that it includes all of those. Section 3 of the bill, it's about certification and publishing of administrative rules. When an agency goes through the rulemaking process and adopts a rule, they then file it with us and it becomes effective. However, that's not the end of the process. There's a back and forth with the agencies regarding small edits, typos, etc. My office also puts in source notes, just like you have at the end of RSAs, so you can backtrack and see what changes there have been. The same thing is done for the rules, and our office does that, and it applies to every single section. This would help the process. Right now, it can be 6 months, maybe even more, before a rule finally gets certified, at which time we publish it on our website. Part of that is due to a backlog for us. Part of it is due to the agencies just sitting on the rule and not doing the certification. I understand that's a lower priority for agencies, but it needs to be done. So this would put into effect some provisions that we think would speed up the process. One big thing it would do is, as soon as, shortly after receiving an effective rule, an adopted rule from the agency, we would publish that online. Right now, it's not published until after it's certified, so it could be 6 months or more before the public, via our website, actually see a new rule. And it's become problematic both with the public and with the agencies. We get calls saying, well, I thought there was a new statute that and new rules. And yes, indeed there are. They are just not published. So we hope that will help the process. Section 4 of the bill deals with interim rules. Those are rules that are effective for 180 days. And there are specific reasons that agencies can use this abbreviated process. Right now, there is no indication in the statute that an agency can do a conditional approval regarding a interim rule. And so that makes this clearer that they can do that. Section 5 simply strikes a citation. That's a housekeeping measure. Section 6 deals with declaratory judgments. If an individual from the public wants to challenge a rule, they can go to Merrimack Superior Court. This would if there was a challenge, it also allows them, the individuals, to challenge that the agency has been enforcing an expired rule. By statute, they cannot do that. Therefore, they can challenge if an individual perhaps has been fined, but the agency didn't have a fine rule that was still in effect, then that could be challenged. And the court would also have the authority to impose a financial penalty on the agency, including payment of plaintiff's attorney's fees. And Representative McGuire has already addressed Section 7 and 7A. Regarding the amendment to the bill, currently the process, if an agency files a rule within 3 weeks of a JELCAR meeting, which is the 3rd or 4th Friday of every month, then the agency's rule will be taken up at that meeting. Right now, we find that agencies are filing close to the deadline. We have to review all the final proposals. Then agencies can do conditional approvals. And we've been finding that by the time everything is finished, it's very close to the GELCAR meeting, and the committee members are not having an adequate time to review the proposed rules and comments. So we are requesting to change the deadline to allow for 30 days instead of 21 days to have a final proposal on the agenda for a specific meeting. We are also requesting a change for conditional approval requests. If you don't know, conditional approval occurs when an agency has submitted the final proposal, we've made comments on it, and then the agency agrees that, yes, we should address these comments. So they ask for a conditional approval from GELCAR to make these extra changes. Right now, there's a 7-day deadline for filing the conditional approval request. We're asking that it be placed 10 days ahead of time. There are also amended conditional approvals. There would be a deadline of 5 days for those. That occurs when we review a conditional approval request. Hey, we have further comments. Agency says, yes, we want to address them. And right now it's happening up to a day or two before GELCAR meeting. Section 11. There's simply a citation change in line 8 in 541A 13 5A. The revision to forms in section 12. There is an expedited process for revising forms because agency forms are rules. In the past, it has not been clear that they can do a conditional approval on that. The amendment would specify that that was possible. Other than that, I would answer any questions.
Great. Representative Grota.
Mr. Morrell, you had mentioned that the bill addresses the record retention of the boards, which I appreciate very much. Does it also address, and I didn't read it, it could be in here, where the records are going to be kept?
Usually it's within their offices, but since all the boards are attached to OPLC, I would guess that it's going to be done centrally with OPLC. But Douglas Osterhout, the general counsel for OPLC, is here to testify, and perhaps he could better address that.
Thank you, because that concerns me where the records are. Thank you.
There was one other point I wanted to make. The title of the act is Relative to Administrative Rulemaking and License Renewals by the Office of Professional Licensure and Certification. Those are two separate things, but I could see that where somebody would read this and think that it covers, that it's all by the OPLC, Administrative Rulemaking and License Renewals. That may be why there are not other agencies in attendance here. We have OPLC and DOJ, but no other agencies such as HHS or Safety or DES are here, which concerns me a little bit.
Hello? Yep.
Yes, thank you. So are you saying that they may not be aware of these changes?
It's possible, yes.
Okay, thank you.
Unless they went into the bills and did a search for 541A.
Okay, thank you.
Representative Mangiapudi.
Will all the records be electronic, or will it be both electronic and physical? That way the storage is in one place.
I don't have the answer for that. I assume that it's going to be both.
Yes, I'm assuming so. Yeah. Okay. Yep. Yep. Follow up.
add to that. So the other that I'm trying to understand is the gray area or the transitional period, 180 days. They could use the old rules while they're implementing the new rules. The agencies can transition that way. Is that my understanding is correct or no?
That's not correct. When the agency adopts a rule, whether it's by the commissioner or by a board, and they file it with us, it becomes effective at 12:01 a.m. the next day, unless they specify a later date for effectiveness. Once the effective date is hit, then it's the new rule that applies, regardless of whether it's been published online by us.
Representative Schmidt? Let's see.
Thank you, Mr. Chairman. Good morning, Mike. This is, this bill and the amendment are entirely the work product of your office, as I have understood, in coordination or conjunction with OPLC as well. So this is part of the process of fine-tuning the GELCAR process and to some degree the OPLC process as we go along and discover that certain things don't work quite as well as they might, or that they should be codified if they are working well. Is that correct?
The bill is primarily our requests. 541A is a fairly fluid statute. We always look for processes that'll make things easier, particularly for the agencies. Sometimes we put burdens on them. The rulemaking process used to be much simpler, but it had no leeway at all for any changes. If an agency had a small error they wanted to fix, the only way they could get it was preliminary objection. Now there are options for agencies, so it makes it a little more complicated. And it does require not yearly changes to 541A, but fairly frequent.
Thank you.
Thank you, Mr. Morrow.
Thank you.
Douglas Osterhout? After your long break, welcome back.
The Sosterhout Office of Professional Licensure and Certification. Forgot for a second what it stood for. Look at me go. Where to start? Let's start at section 1. The office isn't taking a position on this bill, but I do think there's some confusion around our record retention policies. And I remember this argument sort of coming up. Argument might be a strong word, but I remember this issue sort of coming up when we were adopting the PLC 100s. I remember PLC 10205. And it's around record retention. And under our statutory authority, 310.4.1e, it says that the office will, I mean, we can read it right here. The official record of the office of the boards in accordance with the retention policy established by the office. I heard the director testify that there are multiple policies in place, 57 boards, 57 rules, which is actually what we've been trying to get away from over the last few years. And I think we've actually done that successfully. So we drafted up a policy and we worked with DOJ on this and we sent that to archives and that policy was approved. This predates me, but it's my understanding it took about 2 years to get that policy approved. So currently, from our perspective, all of the boards are under the same retention and archiving policy. The current rulemaking requirements are actually under the Secretary of State right now in RSA 529.30.31. That's 5:29. 30 and 31. So I think I'm not sure we really need this section because I think from the office's perspective, we have a unified record retention policy that we've worked on with DOJ. We've got approved by archives. Secretary of State has the rulemaking authority. From our perspective, it's a uniform process and it's a policy that we have in place. I think if we do proceed with giving the office administrative rule, I think we need to be careful about sort of, again, roles and responsibilities. So to answer some of the questions around, oh, and there's another piece I want to bring up before I move on. I think there might be some conflicting language in rule, but part of our big push over the summer is having that contractor come in, that third party, helping us revise the rules for all of the boards. And if there's conflicting language there, that's a place we can clean it up. I'm not sure we necessarily need the rulemaking authority for that instance. And then where are the records kept? Currently, we keep some of the records in the office, but we do box records up. We send them over to the archives. So they are stored through the Secretary of State in the archival process. We are in the process of, are they paper or electronic? The answer is both. We have a vendor through the state that is taking our paper copies and also scanning them to make electronic copies just for better record retention. So, but the answer is still both. And we also, even at the office now, the majority of licensing applications are going to be paper applications. We're trying to go as paperless as possible, but for individuals who may not have a computer, there's still paper options. So I would say it's leaning towards more electronic, but there is still both. The second piece, section 2, notwithstanding any other state law to the contrary. I kind of like this language. I think in the cleanup, it's helpful for us. I do want, DOJ raised the issue, and I think they even think this might be too broad an interpretation, but we might want to tighten that language up a little and say something along the lines of notwithstanding any other state law to the contrary pertaining to licensing terms. I think the concern is when it says notwithstanding any other state law to the contrary, someone along the lines is going to say, well, that means discipline, that means revocation, that means all of the things. I think that's a very broad reading, but we're trying to get out in front of that interpretation. The initial licenses, registration, certifications, and renewals, I don't think I have an issue with. I do worry if it's going to be too limiting. We are adopting, so in House Bill 518, which passed out of this committee, we adopted, well, we put right in that language in RSA 310 that we are using the definition of a license under 541A, which is essentially license, registration, certification, anything that would require state permission. So I don't necessarily think this language is harmless. I'm also not sure if we're going to need it once it's very clear in RSA 310 that license means all of those things in accordance with 541A. So that was in House Bill 518, which we worked on in the fall. I think it was a retained bill and an amendment to that. So those are sort of my comments on sections 102, which pertain explicitly to OPLC. And then my only other concern, and this is a weird position for me to be in because I'm not really speaking on behalf of OPLC at this time. I'm speaking on behalf of somebody who's worked for 3 separate state agencies. And I do have some concerns about the fee piece and the court having authority to level financial penalties. But I'm going to say a few things. One, I think OPLC is trending in the right direction. I think this committee gave the office fee setting authority, which we did in 1002s. It gave us license processing authority, which it did in the 300s. All of those are effective. It says in statute that you can't practice without a license. I think in the future, OPLC is in a good position regardless of the language in this bill. But I do have concerns that I'm going to use OPLC for an example. If we're in a position where we had collected a fee, $155 fee, we are now in a position where we could be fined by the court, paying attorney's fees, and have to reimburse that $155 fee when the individual, let's say it's a licensing application fee, then receive their license. So the person receive the benefit of paying the fee. And I don't want to be the person up here saying, oh, the rules don't matter. They 100% do. And we've pushed really hard to make sure they do. But I think I have this weird perspective because the OPLC has been, because of these roles and responsibilities, reliant on other agencies for our authority. So if the board fails to promulgate rules, it would be the OPLC staff that suffer the consequences for that. And so I am concerned that just statewide, we need to take a good hard look at how we want to implement something like this. Again, that's kind of speaking not as an OPLC attorney, but as somebody who's worked for 3 separate agencies. And then the other issue is I understand that disciplinary action is often laid out in statute, but it's not always the case, and it's not always statute that agencies rely on. And we did a push again in HB 518 where we created sort of a list of disciplinary actions that could apply to all boards. And there were a number of reasons for that. We made the arguments there. But my concern is the wrong people suffer in this case. An administrative agency fails to take action and they allow their disciplinary rules to lapse. I think the harm falls on the public in that instance, because now the agency is put in a situation where the choice is to enforce a rule and fear the retribution of the court. That might be such a strong verbiage, but you know what I'm trying to say. Or allow the bad actor to go unpunished. And there's a lot of cases where I'm not sure. I'm thinking back because I used to prosecute APS rules, and I had an APS case where an individual was accused of sexually harassing an individual with a developmental disability in their care. I worked with police on that. They said there's not enough there to press criminal charges. It's not a case we can prove beyond a reasonable doubt. They did not proceed forward. But the standard at the administrative level was lower, and I won that case, and we were able to put that individual on the registry. And I fear what had happened in that case if APS had allowed their discipline to lapse, that bad actor would essentially be out there still doing whatever bad actions they did. And I mean, I might be thinking in two extreme cases, but these are the kind of things from my experience. I've been with the state about 6 years now, I guess 8 years, 3 different agencies. And so these are just the kind of things that jump out at me when I read the language. I'm not, rules are important. We need them. We need them for due process. We need them for fairness. People need to understand what's going on, but I think we just need to be very careful about what we do to make sure rules are in place. And I also, the director testified to this, and we had a conversation before this hearing. I also would like other agencies to weigh on it a bit more, because like I said, I think from OPLC's perspective, given 518, given 655 last year, given the 300s, the 200s, the PLC 1002s, that we're in a pretty good place for this language, but I think it needs more discussion. I've been up here for quite a while talking, but I'm happy to answer any questions.
Representative Schmidt, and then Lucas.
Thank you, Mr. Chairman. So I think those of us who have some experience in this situation recognize that this is a kind of a tiger we've gotten on board, and that we're kind of legislating on the fly here. So number one is this is going to go to a subcommittee. We're going to have to work this out.
I'll have to check with the chair on that.
Yeah, right. So I would strongly recommend that, because some of these aspects simply have to be worked out, and we can't decide this on the fly. Some of it needs to be investigated and thought about in a way that we can do in this process. So that's the first question. So have you already, my question to you, Attorney Osterhout, is have you been working with Administrative Rules Unit on some of this because it sounds like you haven't. Yeah,
Yeah, there we go.
Mike is kind of funky.
Okay. It just took a second to warm up.
Right.
It's tired of me too. We spoke this morning. I saw this. We haven't really had a lot of discussions about it. I would say I know where a lot of these things are stemming from. So we've probably had discussions around some of this stuff in the past, but as to this particular bill, not until this morning. And I went over and I just kind of told them what I'd be testifying to, so they weren't surprised when I came up here.
Some of this stuff we can clearly approve right off the bat. Some of it, I think we need to have something like a study committee to go forward to deal with this. But some of it needs to be and can be immediately enacted, but some of it can't, in my opinion, so we have to work on it.
Representative Lucas?
This question is just a narrow point. So an earlier speaker said, or at least I took to imply, that the individual boards had rulemaking authority on records retention, but from what you said, that's not the case?
There we go. All right. I think that may have been the case in the past, but our interpretation is that after 655 and sort of the unification of the processes of boards, that became an OPLC process. I mean, right, we are the ones, all the boards fall under us. We have all those records physically, electronically, so we follow the same process. Now, as long as I've been here, that has been the way. It has never been a specific board sort of retention piece. When we look towards the individual statutes for things like what could be revealed to law enforcement for cases, that kind of thing, maybe, but not as far as record retention policy, keeping things for 7 years, how we archive, those types of things. And I can I add one more thing too, is the reason we also did that policy and worked with archives is because there aren't any rules in place.
Representative Grota, and then Manjaputi, and then Goli.
Thank you, Mr. Osterhout. I'm going to challenge you a little bit on
Sure.
that because I don't believe that, I'm hoping that the answer after 655 is that all boards keep their records in the office. But I don't believe that that's the case. I think that some boards have their records out of the office, which concerns me because some of that is confidential information and should be part of the record retention. So can you confirm with me that those records are solely held in the office and not sitting around somebody's credenza somewhere?
They really shouldn't be sitting around somebody's credenza somewhere. We have fought very hard, and I will use the word fight because it's been a challenge. But we did have individuals in the past who had, as you said, records kept in their garage, in their wherever. That's something we are strongly, strongly against. They're not all going to be physically present at 7 Eagle Square because they also go to archives for the state. And so those are maintaining.
Of course.
Right. So I would love to say 100% that we're not aware of. If we became aware of, we would try to track those down. But I would like to say it's 100% because it has been a big push for us to get the records. And if anybody knows of a board member or individual who doesn't or is keeping confidential information in their garage, please tell me so I can track that down. There is another exception for individuals working for us for contracting with the state. They might be looking at files for disciplinary purposes, but we still, we have those locked down. They're maintained confidentially, and we get them back. So that would be the only instance I can think of where it wouldn't either be at the office or with archives.
Follow up.
So is that requirement that the office has control over the files in statute?
I think it is. I think it's in RSA 310-4-1E, maintenance of the official. So it's the duties of the executive director, maintenance of the official record of the office and the boards in accordance with the retention policy established by the office. And that is the policy we worked with Secretary of State and Archives to develop, and DOJ to develop. And I'm also using that language to give us the authority. It's my interpretation that language gives us the authority to create that unified process across all boards.
Representative Manjapudi?
Chair, thank you for taking my question. In terms of record keeping, you said, it's partially physical as well as electronic, and you're also, you mentioned that it's going to be scanned. And so ultimately, the goal is to have electronic records. Even if the application comes in as a physical, you're scanning it, it's stored, archiving it is electronic.
I think so. For one, it takes up a lot less space, but also for things like right to know, it makes right to know requests and our answering them much easier, right? So we can, rather than go dig through the boxes, we can look on the folder. If there's any redactions that need to be made, we can do it on the fly, and then we can send a response to an individual electronically rather than have them go through archives, come to the office, dig through everything, have someone sit with them. I think it's better in the long run for everyone if we can move them all to electronic. So I think that is the goal. Yes.
Follow up.
I'm trying to find the parallel in terms of electronic medical records. So now all the medical records are electronic, whether it's filled out or whatever, and we get the chart access to our file as an individual. So similarly, to follow where your tracking is, where the process is in terms of licensing, who has it, where is it, kind of thing, is that the goal of OPLC to maintain electronic and the process so there's a transparency in terms of the process?
We say that's accurate. Yes.
Representative Goli?
Thank you, Mr. Chair. It's like these mics are on a Monday and just trying to wake up.
I noticed.
Going to section 3, and you being an attorney, I'm looking at some of these changes made in section 3.
Sure.
Looks like just a semantics and wording. You're really not changing much other than someone's personal preference on how they feel it should be worded. Can you tell me, is there really need for changing, I will say, first of all, lines 14 and 15, version of the rule, where it says, which the director shall publish online, when right after it, it was already in the statute that the director shall publish the adopted rule in text online?
I think that probably gets you to the same place, ultimately. I don't have strong opinions on it either way.
And going down to, we'll do the same thing on lines 19 through 23. I understand putting in the publishing or editing on line 20, process shall notify the director. And I don't know why we need who shall make, where it says such changes shall be made by the director where an original statute. And I don't know, can you tell me why it would be, and the rule shall be certified by the agency when we're already talking about the rule at the beginning of the sentence? I'm just looking at these editings and it seems like people are trying to make changes that really don't need to be making work for themselves, that it seems like it's saying the same thing. And then I'll go down to line 24. Agencies has reviewed the edited language and agreed that is certified version, and then taking out the and shall to put which be published online by the director.
Yes.
I mean, I think the and shall be published online by the director is what we're looking for, so I'm not sure why that's struck.
This wasn't my language,
Oh,
right?
I-
So
and
it's
I-
probably better for somebody
You're an
else.
attorney, so I'm asking if
yeah,
I'm reading. I'm missing something.
Yeah, it's interesting. I don't know. I think some of it maybe just to shorten things up, make it a little more clear whether it accomplishes something else. I do think that, and this is, there's a change that, how do I put this? I have concerns sometimes that rules get adopted. They're approved by JLCAR, they're signed, and an agency adopts them. And then I wonder how the public is supposed to know about that because the GenCourt website isn't updated right away. I think one of the things here that, if I'm reading it correctly, it would speed up that process and give the public more access. And I think I would be 100% in favor. The turnaround time on the agency is cut in half, but if we're talking about doing an editorial review of an already approved rule, that would, I think, be an improvement for the public. Some of these comments, I noticed some of the same things you did. I didn't really feel the need to address them here because I thought they might be worked out. And they're kind of policy decisions. To me, I read it as a no harm, no foul kind of, that was my reading on it. I didn't draft this language, so why the changes are in there, I can't really speak to that.
Any further questions? Seeing none, thank you, Mr. Esterhout. J.D. Larrabee, New Hampshire Department of Justice. You can respond afterwards. If you want.
Morning, Chairman, honorable members of the committee. I'm J.D. LaValle. I'm a Senior Assistant Attorney General at the Department of Justice. The department isn't taking any position on the bill, but we just wanted to provide some quick testimony this morning to highlight a couple minor drafting concerns and just one potential consequence of the bill. So I think, as you heard OPLC testify, we did, when we saw the bill, I think on Friday, we did let them know that notwithstanding any other provision of law in Section 2, the potential concern there, I think General Counsel for OPLC flagged that, is just a crafty argument could say, notwithstanding any other provision of law, you said my license is revoked or suspended. Well, there's notwithstanding any other provision of law, it's valid for 2 years. So that was the one concern from DOJ's perspective. In Section 4, I think this is actually just a concern in 541A generally speaking, but Section 4 addresses 541A Section 19, and in Section 11 and Section 19, it appears the statute contemplates boards and commissions, but doesn't contemplate other public bodies that have rulemaking authority, such as councils or committees. So that might be something for you all to consider. And then the heart of the testimony from the Department of Justice's perspective is Sections 6 and 7. I think you heard this morning, the judicial branch, OPLC, and Department of Administrative Services were contacted for the fiscal impact note, but the department's read of the bill, the cost could be potentially more significant to the state. It's clear under Section 7, potential state revenues would be impacted because any fees or fines improperly collected would be required to be refunded. But under Section 6, the Department of Justice resources would probably be impacted if the bill passed because of the potential result in an increase in litigation. So as Section 6 goes over, right, you can now, or the bill would allow for a lawsuit. Agency is definitely going to be a party to that lawsuit, but the agency is potentially, or the state would be potentially liable for a financial penalty and payment of plaintiff attorney's fees. So you have an impact to the Department of Justice. You know, litigation is expensive, both to the state as the Department of Justice, but then also covering plaintiffs' fees. So we just wanted to flag, and I think the OLS director flagged as well. I think that the title of the bill may not have reflected, you know, all the state equities across statewide, essentially. So we haven't done a survey or contacted other state agencies, to be clear. So I'm not speaking on behalf of DHHS or Department of Environmental Services or other licensing or administrative fine agencies, but the department just wanted to make sure the committee was aware of the potential impact. So with that, I'm happy to answer any questions the committee may have.
Thank you for your testimony. Any questions? Yes, Representative Schmidt.
Mr. Chairman, so you were here, I believe, when I asked my question about whether it's going to subcommittee. This is turning into a bigger and bigger can of worms as we proceed with the hearing. So would you be available if it does indeed go to a subcommittee for your counsel with regard to wordsmithing, because there are too many loose ends at this point?
Yes, Representative, the department would make somebody available. Hopefully me, but certainly somebody.
Thank you.
Other questions? Yes, Representative Brown.
Thank you, Mr. Chair. Do you see that there's a problem right now for a person who may have paid a fee under an expired rule for them to get justice, let's say?
Representative, I'm not quite sure I'm tracking, but I think
Okay.
I would go back to OPLC's General Counsel's comment, where if it's a fee for a license and they were issued the license,
It's not, it's all of us.
sorry, yeah, I'm not sure that's a question of justice if the license was in fact issued, right? If there's a processing requirement, right? I just got my license renewed, my driver's license renewed, and it cost me, geez, I should know, but it cost me some fee, and I got my license. Now, if the rule had been expired, and maybe I could demand from the state agency the issuance of the license without having paid the fee, but I think that's a little separate of a question than administrative fine. But I do want to say the Department of Justice's perspective. We're not here to comment on the policy. We just wanted to make the impact known. Certainly, sir.
Seeing no other questions, thank you very much.
Certainly, sir.
Is there anybody who has not yet testified on HB 1622 who would like to testify on HB 1622? And yep, 1 second, Mr. Morrill. Representative McGuire, are you planning on sending this to a study committee or subcommittee? Sorry, let's do. Okay. Okay. If that's the case, Mr. Morrill, if you wouldn't mind, we'll hold off until the subcommittee meeting and you can give whatever additional information you'd like to there. Thank you. Having said that, I will close the public hearing on HB 1622.
Thank you. House Bill 1174. Representative King.
Morning, Madam Chair, members of the committee. Thank you for having me today. My name is Representative Seth King. I represent COAS District 4, which is Whitefield, Jefferson, and the town of Carroll. I presented this bill because I'm a freshman representative, and during the campaign, I met a lady who was a small business owner in my town, and we were talking politics, and she had an offhanded comment where she said her husband is a plumber, and he would love to have more apprentices if he could, but he's only allowed one at a time. So I decided to look into that further. I asked OLS, what statute that was in, and they taught me that it's not actually in statute. What they do is we, the legislative body, have given authority to OPLC to make rules on how many apprentices plumbers are allowed to have at any one time. And they have actually chosen to only allow one apprentice per licensed plumber. I sent out the rule to everybody here. It's actually the third highlighted part. It's towards the bottom of the page, and it explains there's the rule for you. And it is my opinion that that number is far too low. So I can't speak for people in the southern part of the state, although I have heard similar complaints, but I promise you that up north in northern New Hampshire, it is exceedingly difficult to find plumbers when you need them. Even if you have an emergency, it can be very difficult to get somebody to come out. I would stipulate that the reason is because for too long we have had an artificial shortage on how many new plumbers can be trained and brought into the system. So what my bill does is it increases the number to 3. Now, if you read the language of my bill, it can seem a little confusing at first glance. I just want to explain that this bill does not mandate any licensed plumber from having 3 apprentices at any one time. Matter of fact, you could have no apprentices if you so choose. What this bill does is it tells OPLC that they still have the authority to determine how many plumbers a licensed plumber or apprentices a licensed plumber can have, but that they cannot have that number any less than 3. So a plumber can have 1 apprentice, 0 apprentices, 2, 3, and maybe in the future, OPLC will say you can have 4 or 5. I highly doubt that's going to happen. They're probably, if they have for so long kept it at 1, they're probably always going to keep it at 3. But this at least says from now on, licensed plumbers will be able to have up to 3 apprentices. And this isn't going to be a panacea. This isn't going to solve overnight all of our plumbing shortages. But I think that in the long run, this will alleviate a lot of the problems we have with people finding plumbers in their area. Furthermore, this will also help to create more open jobs for people just getting started in the workforce. If you're a young individual and you want to become a professional, something in the skilled, labor market, plumbing might not be an option for you if you cannot find somebody who can train you. If you can't become an apprentice anywhere, then you're going to have to do something else. And that something else might not pay as well. It might not be your passion. So I think that this is going to help increase the number of jobs for plumbers, and I think it's going to help the rest of us get plumbers when we need them. I'd like to address one other thing that may come up. I'm not sure who all is going to speak, but interestingly, and this was, I think, completely coincidental, the Senate has a bill almost exactly like mine. Senator Keith Murphy put up a bill which is exactly like mine, but it says 2 instead of 3. And the day that he was going to testify on that bill before his Senate committee, I talked to him about it, and he said he would prefer my bill, quite frankly. But he went a little bit more conservative just in the hopes that it might pass. I'm optimistic mine will pass as well. But he spoke on it in his committee, and then there were a couple of people who spoke against it. And I would just like to address them because I don't know if they'll speak again or if somebody similarly will speak. But the day that they spoke in front of the Senate committee, they said they had just gotten the bill like 25 minutes earlier. They didn't really have time to wrap their heads around it, but they were against it because they were afraid that this might put them out of compliance with the Department of Labor. And they didn't specify which rule would put them out of compliance with the Department of Labor. I'd like to learn if that's the case. But I suspect actually that they just misunderstood the bill, because I think what they were afraid of was that this was going to mandate that licensed plumbers would have to take a minimum of 3 apprentices. And of course, that's not what that's not what the bill says. But if you look at it just at first glance, it almost kind of sounds like that. But that's definitely not the case. And if you just dig into it a little bit further, I think you'd come to that conclusion. So I think that their fear was unjustified. But if there is any sort of rule with the Department of Labor that might put them out of compliance, I'd happily look into that, and we can amend the bill, or we'll see. We'll take it from there. But I suspect that's not going to be the case when it's all said and done. So I've definitely got many other points I'd like to make as to why this bill would be a good idea, but there are some other individuals in the audience that would like to speak as well, and I don't want to steal all of their thunder. So I think I'll end it here. I'll be happy to take any questions.
Thank you. Representative Gold and then Manjaputi.
Oh, hi. Thank you, Madam Chair, and thank you. Oh,
I can hear you.
microphone's not going to cooperate here today. My question was, did you talk, you said you talked with OP, Office of Professional Licensing, OPL, and so I was wondering, did you ask them about changing the rule?
No, actually, I have not spoken with OPLC. I spoke
you.
only with OLS, and I wanted
Okay.
to pinpoint where that rule was. And there may be a method by which individuals can petition the OPLC to get it changed. I personally am less than optimistic that they would change. I suspect that they want to stick to that rule.
Follow up?
Follow up.
I would encourage trying that change in the rule. I mean, my question is, do you really think that legislating a number versus the flexibility of rule making and rule changing is a better way to go?
Well, I definitely didn't want to write a bill that was going to remove the authority altogether of OPLC. But I also understand that regulatory bodies have a tendency oftentimes to be overly conservative because they're afraid, maybe something happens and then it looks poorly on them. And this way they can just be as conservative as possible without that number being 0. But I am a firm believer. I've lived in multiple countries. I've traveled a lot, and I watch television of foreign countries, and I have seen that there are a lot of states and a lot of countries around the world where their plumbers are fully capable of training more than one individual at a time. I have a very hard time wrapping my head around the idea that New Hampshire plumbers are too inept to train more than one plumber at a time. So.
Thank you, and I'm sure the plumbers appreciate your confidence. Representative Manjaputi.
Thank you, Madam Chair. Thank you for taking my question. My question is, have you looked at the community college or the trade schools in the state that are training, and are they having problem finding apprenticeship for their trainees or in training, especially for plumbing?
That's a good question. No, I haven't, but based on my limited research, even trade schools are not immune from this rule. They also have to, if there's an apprenticeship, they still have to have a certain number of licensed plumbers in order to have the same number of licensed or apprentices. So,
Thank you. Thank you very much, Representative.
thank you.
Mr. Ted Evans.
Morning, Madam Chair and members of the committee. My name is Ted Evans. I'm a licensed plumber. I've been a licensed plumber since 1978 or so, whenever the state licensing program came about. I've been a member of the state plumbing licensing board under RSA 329 when it existed. And I did help with the implementation of the gas fitting portion of the law that resulted in 153-27 to 38. So I'm pretty familiar with the operations of plumbing in New Hampshire. I was a contractor for a while and then went to what we call the dark side of code enforcement. I became a plumbing inspector, and I did that for 14 years, and a building inspector for a number of others. So I have experience both in the trade and as an inspector. I did training for apprentices back in the Manchester School in the early 90s. I've done quite a bit of other training for inspectors. So let me see if I can get the picture as we see it, or as I see it, is that plumbing is not a simple trade. It's very, very complicated. You go to one house, you find one thing, you go to the next house, you expect to say the same thing, you don't see the same thing. And it really does require quite a bit of training. And the tradition has always been one-to-one, that you pair somebody up with somebody who is inexperienced with somebody who is experienced, and then that knowledge gets transferred over. Now, the way the rules are now, I can acknowledge that if you have a big company and you have 15 apprentices and 15 licenses, there's nothing to prevent someone from putting one licensed person on a job and having 10 apprentices on that job with them. So it doesn't really, it goes sort of more for the shop than for any particular work site. And then there's a big division between what we call new installation and service work. New installation is maybe on the simpler side, if we can call it that, but service work and repair gets very, very complicated because there's so much different equipment out there from so many different time periods that it's really complicated. So I'm opposed to the bill because I think that one-to-one works. If there's a problem with attracting apprentices, it's not because we don't have enough opportunities for apprentices. It's that plumbing has become an undesirable trade. We're dealing with human waste. We're dealing with things that are not pleasant. When I talk to young people, they go, plumbing? I would never want to do that. So there's some of that going on. There's also, and I think others can talk about this more, is that there's a problem with training opportunities, not employment opportunities, but training opportunities. If this bill were to be corrected, I would like to see it put money into trade schools and attract people in high school for this kind of work, because right now, I don't think we have that kind of thing going on. You can hear from one of the other speakers that the Manchester School of Technology is lacking instructors in both plumbing, electrical, and by the way, it's the same in other trades. It has nothing to do with plumbing being special and needing more apprentices. The same lack of workers or opportunity for training happens in electrical, plumbing, mechanical, all the different trades. Trades now is taking a back seat to computer study and all those kinds of things. We have to realize that that's what's going on here. The other thing I would like to say is that the image to the public shouldn't be that we have a lot of inexperienced people running around working on people's houses where mistakes are easily made that could impact public safety. I mean, that's what we're talking about here, is public safety. If we don't realize it, we have to, is that the homes that we live in and the buildings we work in, there's a lot of potential dangers going on. And if we have inexperienced people working on these systems, we could be causing a lot of problems. So I'm really kind of opposed on this philosophically and practically, but I think efforts can be made in much better efforts can be made in other directions that would increase the number of workers that we need in New Hampshire. I think I'll leave it there and be glad to answer any questions.
Thank you. With your experience in the trade schools, have you found that graduates of the trade schools cannot find an apprenticeship?
I think apprentices have employment opportunities, whether they're up north or down here, I don't know. But many of the plumbers I talk to would hire an apprentice if they could find somebody who was interested in committing to a 4-year training program. I mean, that's the big apple there, is that it's not a 2-week, 6-month project. It's a 4-year commitment.
Okay, thank you very much. Other questions? Representative Brown, and then Goley.
Thank you, Madam Chair. Thanks for taking my question. So, the first one is very simple. Can an apprentice ever be alone at a job?
I think that the licensing board has been modifying the rules on that a little bit. It used to be that the rules said that an apprentice had to be under direct supervision. And the definition of been modified somewhat, I think, to anticipate that you could be supervised by FaceTime, which is a wonderful thing. That technology is great. If an apprentice runs into a problem and is alone on a project, hey, boss, look at this, tell me what to do with it. Maybe that works, but it doesn't install a lot of confidence in the property owner who's seeing this happen.
Okay. And follow up? Follow up with slightly different question. So you prefer a 1-to-1, but you said there are cases where there may be a large project where it could be 15-to-1. So each individual apprentice can't be very specifically watched in that case. Is that accurate?
I think those kinds of things happen on new construction, where you have a lot of production going on and you have 2 apprentices cutting pipes that are 10 feet long. You know, that's not too difficult. But when you have somebody out in a truck doing service calls, that's another story. And you couldn't really have a licensed person with 2 or 3 apprentices. You know, you go to a house and you're going to show up with 2 or 3 apprentices. That's not where the model will work.
Thank you.
I'm sure that the difference between a 2-week apprentice and a 3.5-year apprentice is significant.
Correct.
Representative Mangiaputi?
Madam Chair, thank you for taking my question. You answered your own question in terms of 1-to-1 versus 1-to-10, and it's not uniform, correct? Plumbing is not uniform. It's not all individual services, services at a home. So my question to you is it better to keep the constraint of 1-to-1 when there's a lot of housing needs, reconstruction, renovation, rebuilding, when we need a lot of plumbers? Would that help to expand this apprenticeship?
Concern over that is having more inexperienced people doing the work. That's not really the answer. We want to have experienced people who know the code and know the practices of plumbing, rather than having a lot of trainees and people learning. If you're expecting someone to come to your house and fix something because you need to have it fixed, are you going to want to have an experienced plumber, or are you going to want to have somebody fresh off the boat, so to speak, and who doesn't really understand what he's doing, been taught some things, but not as knowledgeable as the person who has the license? I would like to say that if there's a possibility of implementing a rule that would govern the ratios on a project, I would be in favor of that. I'm not in favor of trying to make things more costly to the consumer or to the builder or whatnot, but there are other better ways, I think, to get more labor into this field than there is by this bill.
Thank you. Representative Goley?
Thank you, Madam Chair. Speaking of plumbing and the trades and all that, is heating systems included in part of the plumbing trade or not? Doing the piping and everything for...
Heating is referred to as mechanical. We have a mechanical licensing, but the mechanical licensing only licenses plumbers and gas fitters. The gas fitters are the ones who can install gas-fired appliances. But if it's not a gas-fired appliance, there's no licensing for that.
A oil burning appliance has a certification from the fire marshal, but that's it. Yes, you have a follow-up?
If you have an inexperienced person doing plumbing and they don't understand the proper venting or pitches to disperse that stuff, what could happen?
A lot of things can happen. Sewer gas is a pretty dangerous thing. It's methane and it can poison us. It can also cause flammable situations, I would think. And we're talking about venting. I think you might have been referring to combustion gases being removed from the house. Plumbing venting is important two ways. Plumbing venting maintains the trap seal, so that we're not breathing vapors that are coming from the sewer or from our septic system. The trap in that water, in that trap prevents those gases from coming up. And if the venting isn't done correctly, then the trap gets siphoned. Not much, maybe just a little bit, but that's enough to let the gases come into the building.
Thank you. Follow
That would be considered a fairly important safety issue to make sure that those are done correctly and having an eye on that individual while it's being done to protect the safety of an individual.
Sorry, was that a question? I would say yes, it's important, quite important. And that's the reason that we do this extensive training for such a long period of time.
Representative Simon?
Thank you, Madam Chair, and thank you for your testimony. It's been very helpful. Just for clarification purposes, within the context of the conversation about whether or not you want an inexperienced or an experienced person doing the work, in the apprenticeship model, does the trainer have to sign off on all of the work that the apprentice does, check it before it can be approved, or is that a little bit looser?
Well, I think, the apprentice works under the direction of the licensee. So in some respects, the licensee is taking responsibility when in wrong. I would suppose the licensee takes responsibility for it, but he can always blame the apprentice as the one who caused the problem. But so there's that direct supervision. If you're trying to supervise 5 plumbers to make sure all that's being done, 5 apprentices, that gets a little bit more challenging. I think anybody would admit that. Trying to keep track of 3 people as opposed to 1 is 3 times as hard, perhaps.
Follow up? So in that case, where an installation went wrong and something happened, backup, or the homeowner's unhappy, maybe wants to sue and has a case, who would that lawsuit potentially be against? Would it be against the licensed plumber, against the apprentice? Who would take responsibility in that situation?
Lawyer, but I would imagine it would be the company itself would be assume some liability. But there are also complaints that the OPLC can take for unprofessional conduct and violating the code, or there's a whole list of no-nos in the rules that the plumbers are supposed to do and not do, and they can be held accountable. Whoever does the work, I suppose, if it's an employee licensee who makes the error, then maybe that person can be a complaint can be driven on that person for unprofessional conduct. So there's that side of it, and then the civil side, that's legal, and I can't really speak to that. Thanks.
Representative Brown?
Thank you, Madam Chair. So there's obviously a difference between, as was said, an initial apprentice and someone that's been in until their last month of their apprenticeship. Somewhere along the line, is it accurate to say that a plumber would allow that person to be on their own?
As long as they're following the licensing board's rules.
Okay.
All right, Representative, thank you,
Thank you
Mr.
very much.
Evans. Representative Sullivan?
Thank you. Thank you, Mrs. Chair. I come here, I'm one of the sponsors on the bill, and I support this bill because I'm also from the North Country. I think most of the people who are on this bill are from the North Country. And I'll share a story when back in, I don't know, 2020, 21, my sink broke in my kitchen, the pipe snapped off. And so I called a plumber, and this was in, I think it was September of that year, and they told me they could get to me in November. So who can live without a sink working in for 2 months? Like, that's insane, right? Fortunately, I have I'm the only male in my family from my grandfather on down who's not a plumber. And so I have a lot of people, they don't necessarily live close to me, but I have a lot of people that I can, pull the family card with and have them come help me in these sorts of, essentially a crisis if your sink's not working. And I tapped into that when this bill came up, and I was like, well, what do you guys think about this? And my brother, who lives here in New Hampshire, he was like, yeah, I think 3 is probably about the upper limit of what you would want, just because it would become hard to manage them, certainly on a job site, if you have a bunch of them running around. He goes, but yeah, definitely we could have more than one. He goes, it's most of the time I'll spend time with and he's a master plumber. He goes, most of the time I will spend one-on-one with somebody initially in the early phase up of them, but then you kind of send them off and then you go and check in on them. And he goes, it wouldn't be hard to manage 3. He goes, if you guys change it to 10, I think that would be a problem because it would be really unmanageable. But 3 he thought was reasonable. I talked to my cousin who is also a plumber. As I said, all the males in my family are plumbers. I somehow missed it, which is too bad because they make so much money. But he's like, yeah, he's like, oh, it's totally reasonable. Like, he goes, we benefit from a lot of the regulations that we have in the plumbing industry that drives up the cost of plumbing because it does keep down the cap of plumbers, whether it's the apprentice program, whether it's the number of hours needed. There's a lot of regulations there that perhaps are overly conservative, as Representative King has suggested when he was giving his testimony. But another point that when I was talking to my brother in great detail about this last week, and he said, he's like, one of the good things that would be good about this is if I could have 3 come on. Because the problem is as the previous speaker said, a lot of people don't want to do trades right now, so they come in and then they do it for a month or 2 and then they drop out and then they have to start over. He goes, if I had 3 and I have 1 or 2 drop out, at least I still have 1 who might make it through the whole program. It really increases your odds. And he said, that's where I think this matters the most. He said, the biggest problem is if we could only have 1 right now, they often don't last more than a month or 2, and they don't like that. And I know the plumber that I use, I represent Bethlehem, and I own a property in Littleton, and I had the local plumber there, and I spoke to them about it. And when they heard that I have a lot of family in plumbing, they asked if I wanted to become a plumber to work for them. And so I do think that there's a problem with trying to recruit. To the previous gentleman who spoke, I think there's a big problem with getting kids today to want to do that. That's just not easy to do. And so I really do appreciate that. But if you have 2 who are willing in that moment, it'd be great if you could take both of them in that moment. And I'm not sure that that's going to happen often, that you could take 2 or 3 at a time, because I don't know that there's the supply of people who are willing to do it. But if that opportunity presents and a high percentage of them drop out, it would be really shameful to think that, we only could take 1 to have them waste 3 months of time and then have to start the whole process over again. If we really do want to increase the pipeline, what we need to do is give the tool and the flexibility among these companies. And again, what's important, and I think it's really important to remember this does not require anybody to change the way they're currently operating their business. But if you are somebody like my brother who thinks having 3 would not be a problem, then they could do that. And then they could manage the 3. And then when 1 or 2 of them drops out, we still have an extra plumber going through the program. And that benefits all of us, because as we all know, at least for me, I think the biggest problem facing the state is the shortage of housing. And one of the reasons why we have a shortage of housing is we don't have enough people trained to build houses and construct houses. And we have an aging state. So a lot of the people in the trades specifically are retiring, and there's not young bodies coming in to sort of fill in the gaps. So I really hope that you guys take this, it's a pretty small change, but I hope that you guys really take it seriously. I really do think it has the potential to, move move the ball in the right direction in terms of reducing the cost of constructing houses and getting people to fix things when they break, like my sink. That would have taken 2 months if I hadn't had connections. So with that, I'll take any questions.
Thank you. Representative Mangiaputi.
Thank you, Madam Chair. You answered some of that, but I want to ask, how are the other neighboring states doing this? Have you checked if it is one-on-one or more than one apprentice? I know in Vermont it's different.
So I texted my cousin as I was sitting here waiting, and that's why I delayed my speaking, because I was hoping he'd get back to me. So I asked him, he works in Massachusetts, not in New Hampshire. But I think you can now work in both now, I believe. But he says that it was one apprentice per plumber, but he believes they changed it this year, and he was looking into it, and he hasn't gotten back to me yet. So I don't have that answer right now. Sorry.
Thank you. Follow-up?
Thank you, Madam Chair. And again, the consumer at this point has the choice. I could ask for a plumber, pay exorbitant price for an emergency visit if I have a sink leaking. And if that is not satisfactory as a consumer, I can say I don't want this coming back, or I can go back to a different one, isn't it? So the choice for the consumer, like you had for 2 months, but there is choice right now to get whether you want master plumber, or apprentice, whatever.
No, Representative Mangiaputi, that's not correct. Right now, you need to have a licensed plumber performing work unless you're doing it yourself. And whether the plumber is a master or a journeyman is not relevant, really, but they need to have a license, or it's illegal.
So that it's already covered that they can't send an apprentice without a license.
Oh, no, apprentice has a license.
Okay.
Any other
I think what
questions?
this
Thank you.
would do would to sort of address your question. I think you could certainly, let's say you had a problem at your house and you had a plumber come and they sent an apprentice who maybe wasn't as skillful enough. I think maybe this is getting to the heart of your question. I think you could certainly reach back out to them. I think any business, I can't imagine plumbing would be any different. You could reach out to them and say, listen, that guy did a really bad job and I want you to come back and fix it. And I also don't want you to ever send him again because I don't think he's skilled enough. I mean, certainly you could have that discussion. But I think one of the problems is there just isn't enough plumbers. And so, you're going to be waiting a long time in some cases, particularly if it's not an emergency, or in my case, even if it is an emergency, you might still have to wait months. So oftentimes it takes time to get an emergency to be able to get things done. And I could share other stories from my apartment building that I own, and it literally took it to getting an emergency point before they could come and address it. And so we need to think about ways, and I appreciate what the previous speaker said about expanding trade programs and opportunities. And that's one of the many levers we should be pulling to try to increase the capacity of the plumbing industry and the trades industry more broadly. But I do think that this is an important. I don't think it would be particularly dangerous for society to have a little bit of a expansion.
Okay, thank you. Representative Baroda?
So, Representative Sullivan, are you aware of a glut of apprentices and they don't have plumbers? Or is it the other way around?
It's probably the other way around. But I think that kind of misses the point of this bill, though, because if there was a glut, it would be a no-brainer we should be doing this, right? But that doesn't mean there aren't instances where there maybe is a glut for a specific town and they can't, and so people can't get in. And we wouldn't want to create that if that does happen, to create opportunities for those kids to get into the program, or people.
Thank you. I don't have a follow-up. Thank you. That answers
you.
my question.
Thank you. All right, Mr. Trombley?
Morning, Madam Chair, committee. members. My name is Bill Trombley. I'm from Manchester, New Hampshire. I I have run a family plumbing and heating business for over 50 years. I'm a master plumber. My master plumber license is actually number 1. And my father actually started the plumbing licensing law way back in 1978. So I could talk about this subject forever. In concept, I agree with Representative King's concept that we need more plumbing apprentice. The problem that I see that people I don't think realize is New Hampshire doesn't have a plumbing apprentice program. So, period, we don't have a plumbing apprentice program. New Hampshire uses the federal government apprentice program, the federal Department of Labor, not the New Hampshire Department of Labor, the federal Department of Labor. So in the rules and in the law, it points over to RSA 278, which is the Apprentice Council, which we kind of all know it's not really there, and it's the federal government. So even if you pass this law and you change this law, it's not going to make any effect, because as a company, as a business owner, when I sign up an apprentice, I have to sign an agreement with the Department of Labor, Federal Department of Labor, that I'll follow their rules. Okay, and their rules is 1-to-1, and it goes on past that. So this is not going to change anything, because in order to register as a plumbing apprentice in the state of New Hampshire, you must first register with the Department of the Federal Department of Labor first. So it doesn't change anything. Unlike with the electricians do have a state of New Hampshire plumbing apprentice program. With an electrician, you can either sign up with the Federal Department of Labor, or you don't have to sign up for the Department of Labor. Basically, what that means for the electricians is, if you're doing a federal project, if you are not registered with the Department of Labor, you can't do a federal project. Okay, so for a small company like me, doesn't really matter. But because I'm a plumber, I still have to do that. So I agree that there could be some work in this area that could change it. That plumbers could have, 2 apprentices, 3 apprentices. I'm not quite sure. I definitely agree with 2, maybe 3. Apprentices that should be out there and answer. So just to answer some of the questions that are going on, if you're a 3rd year and a 4th year apprentice, you're allowed to work on your own, as long as you have supervision from your sponsor. This is the term from the federal government. They just want you to have supervision, and their definition is any electronic supervision or anything else like that. New Hampshire has recently changed their rules and laws, I think is December of last year or November of last year, that a 3rd year and a 4th year apprentice can work on their own as long as they're supervised by a journeyman or a master. Talking about the gas license, you have to have direct supervision all the time. So you got to also realize is the plumbing school is a 4-year plumbing apprentice. Realize that we're getting more people signing up for the gas license than we are plumbing. It's a 1-year plumbing, 1 year for gas fitters versus 4 years for plumbing. So it's easier for somebody coming out of school to go get their gas license. I'm not necessarily agreeing with 1 year. Don't get me wrong, but that's what we're seeing when kids come out of the school, and I think could be more work. Like Mr. Evans said, we were just notified that the Manchester School of Technology, their plumbing and electrical class does not have a teacher for plumbing or electrical. And it's tough to get a tradesperson in there because I believe, I'm not 100% sure, but you need a teaching certificate to teach in that school. It doesn't make sense for somebody that is a plumber that you can't go in and teach plumbing, that they don't have a teaching certificate. And I know that's getting out of this committee's purview, but just to kind of let you know, that's what's going out there. So in concept, I believe that we should allow more apprentices. I'm just not quite sure that by changing this here in this law, it will do anything, because the plumbing program is a federal program. And with the federal program, one of the advantages of that is we have portability, is that if somebody is in this program in other states and they come to New Hampshire, they can pick up where they are, where they left off. The truth of that is probably maybe, I don't know the exact number, but there's not every state is on the federal program. Massachusetts is on their own program. Maine is on their own program. I'm not familiar with Vermont. So immediate area, it doesn't do too much, but there are other states that are on the federal program, and they can move from one state to another. So I think you have to come at it at a different angle if you want to change the plumbing apprentice program ratios. So I'm happy to answer any questions.
Thank you, Representative Schuett.
Thank you, Madam Chair. Hello, Mr. Trombley. It's nice to see you again.
Nice to see you.
Would you agree that a master or journeyman plumber would probably make more money on the job than he would teaching, and that might be a reason that we have a shortage?
Probably, but there's a lot of good and bad things about the working. As you might see me walking in here, I'm limping. I need 2 new knees and everything else like that. So I don't think somebody. I would love to teach. The plumbing is in the blood, so people sometimes would like to teach, and money is not always the answer.
Thank you. Other questions? Representative Schmidt?
Thank you, Madam Chair. So it was briefly referenced earlier by Mr. Evans, I think, but isn't it the case that new construction and older homes, or existing homes, 2 different worlds, and maybe you could speak to the totally different situation you have when you're building a new building.
Yeah, the great thing about plumbing is that there's all kinds of different aspects of it. You have the service, which is we're doing the repair, like repairing the sink. You have new construction. When you say new construction, you're building new homes and stuff like that. And then you have commercial that is building these commercial buildings around there. They're all different types of work. The thing is with the ratio is a company ratio. So I have to have 1-to-1. But if I'm on a job site and I'm a commercial type of plumber, I could actually have 5 or 6 apprentices with a journeyman that's on that job right now. That's legal. Okay. That works well for their situation. The problem is when it comes into the small companies, it's 1-to-1. Now I'm sending 2 guys out to fix a kitchen sink, and exorbitant fees. They're not exorbitant fees. I hate to say that, because you're paying for our education, you're paying for our knowledge. I'm sending 2 technicians out on this job. And yes, if he's a first year apprentice, he's still making pretty good money. He's still making $20-25 an hour. Okay. So, and then my plumber is making well over that. So, that's where the cost goes up for the residential. And I did utilize, I do utilize the 3rd and 4th year. Yeah, they should be able to do something. 3rd and 1st year, I was running jobs when I was the 3rd and 4th year. They should be able to replace toilets, no problem, 3rd and 4th year. Fix a kitchen sink, 3rd or 4th year. Those are things, and I think we did well when we got that rule changed into December. It hasn't got out to the industry yet. It just hasn't, the notification hasn't got out to the industry, so we haven't seen any of that effect on that yet. But definitely, my good friend, Mr. Evans, and I may disagree, but I would have no problem, having 1 to 2, maybe 1 to 3, but that would be a good start. But I think it's a major change in just changing this law.
All right, thank you. The other questions? Thank you for your testimony.
No, I just have one for
Yes,
Mr. Osterhout
Representative.
if he comes up.
We will invite him to speak next, I believe. All right. Does anyone else wish to testify? Commissioner, Mr. Osterhaus? All right, then we'll, since we have a question for Mr. Osterhaus.
Douglas Osterhout, OPLC.
Okay. Representative Lucas, you have a question.
We heard testimony that that the apprentice program for plumbers is just under the federal, and that even if we were to change this to 3, it would have no effect because there's a federal one-on-one. Is that your understanding?
I would have to look at it more, but it's my understanding that we do have the ability as a state to go above 1-to-1, but when we do that, we lose a lot of federal dollars. We lose grants. We lose. The examples given to me were, there's grant money at the 1-to-1 ratio where they'll buy equipment for apprentices, they'll boots, belts, tools, that kind of thing. There's education money there if you're at the 1-to-1 ratio. And again, as Bill pointed out, there's the you can't do a federal job at 1-to-1. We could go above 1, I believe, in rule right now if we wanted to, but
That answers my question.
There's drawbacks.
I have a question. Could you tell us how many plumbers there are in the state and how many apprentices?
I can get that number for you.
Thank you. I think that would be useful because if the problem is that we don't have enough apprentices, period, then I'd be less inclined to push this through than if the problem is we don't have enough jobs for the apprentices. Although if the problem is that all the apprentices would rather live in the bright lights of Manch Vegas than go up to Coos County, that's not a problem we can solve very well. Anyone else? Representative Brown.
Chair, and thanks for taking my question. It would be possible, I'm guessing, if we wanted to move forward with this to make possibly categories 1 to 3, and the first 2 years they couldn't be left alone, for example.
I think you could give the board the ability to do that. They might have that ability right now. I would have to look at the statutes to see what their rulemaking authority is. Somebody else may be able to speak to that, but
Well, if this number is only in the rule and not in the statute, then that strongly implies it's within their authority.
would say
I
that-
would hope so, at least.
Yeah.
Well, you're talking about categories,
Follow.
though, right? To be clear.
To be clear, I'm saying we could say a plumber could have 3 apprentices, but the only ones that could be unsupervised directly would be year 3 and 4, for example. It's already in there. Okay. Thank you.
Okay. Other questions? All right, thank you very much. If you could also, while you're looking into the numbers, report on what kind of grants we're getting and how much money is involved. I mean, if it's a tool belt type of grant, I'm not too worried about it. Other questions? Thank you very much. Yes. What's that?
To clarify any of these questions?
I'm inviting everyone. Is there anyone who wishes? Yes, please. I was just waiting for Doug to stand up to do that.
How's that? Thank you, Madam Chair, Committee. My name is Wen Young. I work for the U.S. Department of Labor, Office of Apprenticeship. I can answer some of your questions. Currently, for plumbers in the state of New Hampshire, the Mechanical Licensing Board will not issue an apprentice card without an apprenticeship agreement from my office. To get an apprenticeship agreement from my office, you must be a registered apprenticeship. Okay. Registered apprenticeship is what we do. Previously, the state had been the registration agency, but now the federal government is. To answer the question, all of the states around you in New England are what we call state apprenticeship agencies. We are the only Office of Apprenticeship, or OA, state in New England. With that being said, the idea is that the registrations occur. We provide the information to the apprentice and the sponsor of the apprenticeship of the apprenticeship. Sponsors are normally the companies that are involved. Sometimes they are organizations, such as the Plumbers Union is an organization that has a fairly significant program. But this is why currently the plumbing apprentices are at a 1-to-1 ratio, because that's based upon direction from the Office of Apprenticeship, which is, my direction comes from the Office of Apprenticeship in Washington, D.C.
Oh, so it's all your fault then.
Yes, ma'am.
Okay, excellent. Glad to have that settled. Is there any likelihood of that being changed anytime in the near future?
Currently, the policy is that a sponsor may request a waiver from the Office of Apprenticeship. And so when I say sponsor, that would be the company or the organization that has the apprenticeship program, can request a waiver to change their ratio. There are a number of requirements that they have to meet and demonstrate to be able to do so. Some of those things include their safety record and their completion ratio for apprentices.
So that a company that has 5 master plumbers and is currently doing 5 apprenticeships could ask if they had a good safety record, and actually their apprentices move on, could ask to go to 10 or 15 or 50.
They could ask for a higher ratio. Yes, they could. That would be, there is a process in place for that.
Thank you. That's good to know. Representative Mangiaputi and then Simon.
Thank you, Madam Chair. Thank you for taking my question. Is there, in the waiver process, is there any special consideration for underserved or highly shortage area to get a waiver?
The waiver is based primarily on performance, safety performance, and performance of the program itself overall. The Department of Labor, as you're aware of, the U.S. Department of Labor has a very strong DEIA policy in support of underrepresented communities. So it's not necessarily a part of the discussion, but it is in there.
It's available. Thank you.
Anyone else? Representative Brown.
Thank you, Madam Chair. So is it accurate what was said before, that if this bill were to pass, it would be irrelevant?
If this bill passes and you're still registering apprentices with my office, yes, sir, we'll still be at 1.
That's definitive. Any other? Representative Simon.
Just real briefly, thank you for taking my question. In the waiver process in the state of New Hampshire, historically, when people have received waivers, what has that ratio been? Has it just been 1 to 2? Has it ever been higher?
It depends upon the occupation.
Plumbing specifically.
So plumbing, I have not seen any request for waivers in plumbing from the state of New Hampshire. We do have a waiver in effect for a different occupation and a different company, but I have not seen any go through for plumbers.
Well, that's useful to know, so that companies could start asking for a waiver tomorrow.
If they call my office, I'll give them the direction that they need to help them.
Thank you very much. That's good to know. Any other questions? All right. Thank you. Thank you for your testimony and for the information. Does anyone else wish to testify? All right, seeing none, we'll close the hearing. We are resuming at 1:30 p.m. Excuse me, at 1 p.m. My mistake. There's a committee and then a commission. All right, welcome back to eDNA. I'm opening the public hearing on House Bill 1252. Representative Gould, are you going to be presenting it? Representative Lekis is going to present it. Excellent, thank you.
Madam Chair, this would establish a committee to look at a number of things, to get input from Native American communities in New Hampshire and others. And one of the big issues is investigating the possibility of state recognition of the tribe. Abenaki have been recognized officially in the state in Vermont, not in New Hampshire. And there's a number of reasons why this matters. There's a number of, there are tribes that are recognized by the federal government and tribes recognized by state governments. The Abenaki are recognized currently by neither, Vermont, but in New Hampshire, neither. And there's a number of federal laws that can be of benefit to the Abenaki, who are citizens of our state. One issue is being able to sell crafts. I think they do basket work and other things as Abenaki, and there's a federal law that if you're selling that and you're not a member of a recognized tribe, either by the state or the federal government, there are actually really serious fines against doing it. And my understanding is that's starting to actually be enforced. And so you have people who are Native Americans, Abenaki, they may produce some traditional handicraft, but they can't legally sell it. There's a written testimony, which I think was just handed out from someone who provides more detail on that than I can. So that's that. There's some other laws. For example, there's federal law on things like migratory birds and other wildlife where there are specific exceptions in place for recognized tribes. Allowing them to keep feathers from some birds that would be illegal otherwise, and some other animal materials. But unless they're recognized either by the federal government or by the state that they're in, that does not apply, and they can't take advantage of it. And there's some other federal laws having to do with Native Americans that, again, only apply if the tribe is recognized. And the authority for doing that recognition is explicitly with the general court, the legislature of the state of New Hampshire. So this is something that's appropriate for a committee made of legislators to look into. That's basically the point of the bill. And I'll try and answer any questions, but I think there are people who will be able to, provide more detail on some of it than I'll be able to.
Thank you, Representative Lekis. I believe you're correct. All right. Kristen Osser Allen. Oh, if they're together, that's fine.
Good afternoon. I'm Madeline Wright. I live in Alton Bay, New Hampshire, and I'm here today representing the Mount Kearsarge Indian Museum in support of HB 1252. I am a citizen of the Nalhegan Abenaki tribe. I was appointed by the governor and served as a member of the New Hampshire Commission on Native American Affairs for one full term, and am currently a member of the Mount Kearsarge Indian Museum Board of Trustees. I would like to introduce my fellow trustee, Kristen Osier Allen.
Hello, my name is Kristen Osier Allen. I currently reside in Bow, New Hampshire. I am a member of the Passamaquoddy Nation out of Maine originally, although I currently reside here in New Hampshire now. I am also on the Board of Trustees for Mount Kearsarge Indian Museum.
The Mount Kearsarge Indian Museum supports efforts to better understand the needs and aspirations of Native Americans in New Hampshire and beyond. Our hope is that any committee looking at these matters would be allocated adequate opportunities and resources to complete a thorough and careful study. Thank you very much for listening to us today. Are there any questions for anybody?
Thank you. No, thank you very much. Very clear. Tina Daniels.
Hello, good afternoon. I am Tina Daniels and I live in Goffstown, and I am an enrolled member of the Nulhegan Cossack Nation of Vermont. And I believe we need state recognition because at this point, all the surrounding states in New England do recognize their Indigenous people, whether it's federal or state recognition. And New Hampshire stands alone without that. And I do support House Bill 1252. And because we have no official state recognition, it can be very hard to get grants for cultural programs here in New Hampshire. And this is something personally I've been having to do. So we go to Vermont to access the programs that are happening there. And they do run a lot of programs. And because they can get the art grants there much more easily. And I just came back from one 2 weeks ago that was held for 2 days in Burlington. And they bring in instructors from Indian instructors, Native Americans from other states to run those programs for us. And I also want to say that I support House Bill 1474, but I have another meeting in my hometown this afternoon, so I have to leave for that. Thank you. And, oh, are there any questions?
Thank you for your testimony. Yes, there are. Representating Groda, then Brown, then Manchaputi.
Thank you. Thank you. Could you kindly tell us about these art programs and what their purposes are?
The purposes are to help bring back the culture that we've lost. For example, the program I attended 2 or 3 weeks ago, and it will be held again in April in Vermont. It's to help with weaving programs, quill work, which my grandmother, who was here in New Boston and came from Quebec, both my grandparents, they were big weavers. But because they were actually born in the late 1800s, and I have her loom, but that skill was never passed on to me. So it's reawakening skills that were here, but had to be suppressed because it was certainly not considered the thing to do. I can just tell you this, my mother, who is not Indian, worked for the state of New Hampshire in the 70s, and I was extremely firmly told to never talk about it because she was afraid of losing her state job at that time. I do have my grandmother's loom. And so these programs that come in from out of state are bringing back quill work, weaving, ceramics, anything related to our culture that it wasn't just Abenaki, but all Northern Indians did, working with birch bark, everything like that. And in fact, there is another workshop in March way up in Cabot, Vermont, I'm going to. And that's what we can't access here easily because I asked the person who started the programs, Vera Longtoe Sheehan, I said, why are all the programs in Vermont? Because it's a long ways to drive and I have to stay overnight. And she said, because we can't get the grant access easily in New Hampshire. And she said, so for this coming year, 2024, they're all going to be in Vermont. Okay.
Representative Brown?
Oh.
Thank you, Madam Chair. Can you expand a little bit on what Representative Lecca said when he introduced this? And we have a piece of information from a person in Bristol who's in Nullhegan as well. Can you expand a little bit on not being able to sell products unless it's a recognized tribe?
I don't personally understand that much because I've never tried to sell a product, but Sherry Gould, who is also a rep, is a juried member with the league, so she could probably explain that better.
Yes, thank you. If she's going to testify, we'll do that. Representative Mangiaputi and then Bailey.
Thank you, Madam Chair. Thank you for taking my question. I'm here. I'm in Vermont. Do you know when this law was passed and how they were able to access? These are federal grants, I believe.
I don't know that answer. I can ask our chief because he would know. I believe they achieved state recognition, I want to say around 2006, but I'm not sure.
Okay, thank you. If you could send us a note about that, we'd be very interested.
Okay, thank you.
Thank you. Other questions? Don't see any. Thank you very much.
Okay.
Paul Puglia.
Good afternoon, committee. My name is Paul Pulio. I'm the Sagamore or principal speaker for the Cossack Band of Pennacook Abenaki people. We're headquartered and located in Alton, New Hampshire, and I've been a, as you call, a seated chief since 1990.
Hi, my name is Denise Pulio. I'm the head female speaker of the Cossack Band located in Alton, New Hampshire. I am also the vice chair of the New Hampshire Commission on Native American Affairs. I'm affiliate faculty for the Native American Indigenous Studies minor over at UNH, and I am also the president of New Hampshire Public Health Association.
Thank you.
We come to you today to oppose this, not on its principle of like it has good intentions, but it seems to be quite redundant, and it's a piece of legislation that's looking for a problem when in fact the Commission on Native American Affairs has already been addressing all these issues and ongoing for the last few years. And like I think it was Peter Smith said, we don't need legislators looking at our problems. We can do that ourselves and come up with some determinations on how to solve these things. What is not obvious to all of you that a recognition process is a very detailed process that is going to cost money to the state. In all candor, if it's done properly and it comes anywhere near the federal process, there's going to be a need for professional genealogists, professional historians, and you can't ask me to do that. You need to hire outside experts for this kind of work. You can't expect us from inside the community to jury ourselves on these issues. You have to hire experts on that. And it's going to, if this goes forward with any recognition process, it's going to cost the state quite a bit of money. Quite frankly, we do a lot of genealogy, and it's running in excess of thousands of dollars per family to prove and vet historical documents. So just be prepared for that as you go through the process, because people will be submitting genealogy, and you're going to have to vet that through professional services. The other issue is the Arts and Crafts Act, which comes up quite a bit. As a tribal leader for over 20 years, we've tangled with the BIA on this issue. And the original Arts and Crafts Act was meant to protect certain Western tribes and those that made silver and blankets and things. And they've done a lot of overreach. They've tried to get into everything from literature, like if you've written a book and you say you're Abenaki, you could be fined. But it's never been tested in court with how far they can go with this. We've tangled with them by saying that we are descendants of the Pennacook, and they have backed off from any litigation against us. And we also question the sheer numbers of people. You're trying to create legislation, you don't have enough facts, in my opinion. You don't have enough facts about how many actual artisans and craftspeople actually being impacted by the Arts and Crafts Act. And the very fact that people have Vermont status and they're a part of Vermont tribes, that's transferable to here. They can sell their arts and crafts anywhere as long as they have that state status. So I don't understand the duplicity of having to have another recognition in this state just to sell crafts. So in a nutshell, I don't think this bill is needed this time. The commission, as you see in 1474, has been very proactive to try to improve the way it operates. And these issues have already been come up, and we've already talked about how to process this and how to deal with these issues. And to us, having legislators play inside of our camp, so to speak, is not necessary. It's just a waste of taxpayer money, and we would recommend that you either table this or put this aside unless the commission can't act to respond to these things in the next year or so. So with that being said, this is already on the agenda, arts and crafts. Although we don't have vetted authority to approve anybody, we can bring up these subject matters. We don't have any authority to recognize anybody, but we can at least bring it up and try to come up with a game plan how to deal with that. And that would be my personal opinion from a tribal leader. Now, as a commission member,
Right. As a member of the New Hampshire Commission on Native American Affairs, this bill was actually never even proposed to the commission. We never received a copy of this bill. It was never brought up to us. As a commission, we're made up of community members as well as state officials that have positions within the commission to give state oversight and to give us access to state resources. So adding another layer of oversight to the commission is just a waste of taxpayer money.
do we have
Thank
any
you.
questions?
Don't see any. Thank you for, excuse me, Representative Gould.
Thank you, Madam Chair, and thank you for taking my question. The commission did not read and vote to support it? The commission didn't read this bill and vote to support it?
1252?
Yes.
No, they did not. They did not support this bill.
I guess I was misinformed. Thank you.
Yes, the chair, Ann Jennison, actually submitted online testimony on behalf of the commission.
Thank you. We'll have to study that. Representative Mangiaputi?
Madam Chair, how many different tribes that exist in New Hampshire? Do you have that statistics?
Specifically Abnaki or intertribal tribes or?
Just in terms of the commission, it includes all of it, correct?
So the commission is open to all residents who have indigenous descent here in who live here in New Hampshire. So they don't necessarily represent a tribe. Sometimes they just represent their historical background as being indigenous. We have Blackfoot, Cherokee, and others that currently serve on the commission.
Thank you.
Taino, the list goes on.
You know, by the way, none of those really would apply for recognition, nor with
they
arts
wouldn't
and crafts. If they have arts and crafts permission, they get that directly from their own tribal communities.
Thank you. I don't see any more questions. Representative Smith?
Madam Chair, do you require like a DNA test before you prove, you don't really prove? So I could walk in there and say, I'm an Abnaki, and you would accept that?
No.
Absolutely not. We deal with deep genealogical research, and you need vital records to back that up. We're finding that Ancestry.com is filled with a lot of false leads, and you need to have the backup. You know, vital records mean birth, death, and marriage certificates, and typically in the Abnaki culture, it goes back all the way to late 1500s. And when we engage a genealogist, you're talking, in my case, 15 generations of research. And if you just look at what it costs to have a genealogist do research on that, they can only do, for $3,000, we've got quotes, $3,000, only 5 generations of detailed, analysis.
Follow up?
I did genealogy at the American Canadian Genealogy Society for quite a few years, and everybody that came in the door, of course they're Canadian, or descent. And they all said, oh yeah, my Indian ancestor. And you question them, and they said, well, I've got high cheekbones. So that, you know, enables me to be a descendant of some Indian or Native American. I think 99% of the people that say that are not. And the only way I can tell them to prove it is to have a DNA test.
There is no DNA database for New England tribes of any substance. This has been a dilemma because archaeologically, we've always proposed, you know, any human remains we find in Hampshire to do DNA, but other tribal groups strongly oppose that because we've been trying to do this scientifically to prove that there was some kind of distinct DNA strain that would have been here in New England. Every time we've ever found any remains, which is very infrequent, the last one we found was in Freedom, New Hampshire, and it was very, very strong opposition for us, and we wanted to do a tooth test, which is one of the few archaeological places where you can find DNA. And the date of the human remains were probably, what, 2,000 years old? 3,800. 3,800 years. It would have been great if we could have done that, but we had such strong opposition to it. So the DNA issue is still a very strong one, but it's not precise. And you know, we still look at it as one of the tools, but it's not here at that point. We could actually use it. We go back vital records. In my case, I've got multiple lines as I do more and more digging, but it's you know, if I had some old ancestors that could do DNA, it would have been great, but I just don't have them alive anymore. Okay.
Okay, thank you.
Okay.
Questions? Seeing none, thank you for your testimony. Is there anyone else who wishes to testify on House Bill 1252? All right, seeing none, I will close the public hearing. Okay. So we have a few minutes. We'll go into executive session. Representative Grota.
Yes, Madam Chair, I move OTP on this bill. I think that this committee has heard testimony about this, and I think it's time that we look into it. And I think a study committee is an appropriate way of doing that. I don't think that this is something that we want to take lightly, and I hope that the committee will support the OTP.
Is there a second? Representative Mangiapudi, do you wish to speak to your second?
I want to make a point about, yes, a few years ago, a senator in Vermont state did introduce this, and they have since been able to access some of the funds specifically for education and expansion of the tribe skills and including them in the larger Vermont stuff. So with that, I will say, yes, I'll support that.
Anyone else? Representative Blackus?
Just to address one concern that was raised about potential cost of tribal recognition. I mean, that's one thing for the committee to look into. The committee can't obligate any money. It would just propose future legislation.
Yes, I would have to agree that it's not in the scope to start the registration process, just to say we think it might be worthwhile. Any other comments? Questions? All right, then the motion is ought to pass by Representative Groda, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis. Representative Bailey.
Yes.
Representative Dolan.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
No.
Representative Goley. Representative Schuett.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiapudi.
Yes.
And the chair. 14 yea, 2 nay.
Motion passes 14-2. Is there any objection to consent? Representative Schmidt objects to consent. Okay, we'll put this on the regular calendar. And I will say that my issue is that this is not a study committee I would want to serve on, so. And that's one. Yes, exactly. All right. All right, thank you. You can do it at your very earliest convenience. Okay. All right, thank you all, and we'll close the executive session. Okay, I'm opening the hearing on House Bill 1474. And Representative Schmidt, are you introducing this? Are you introducing this? You're the prime sponsor.
I'm the prime sponsor, I think I should be up there.
Thank you, I agree with you.
Testing.
We hear you.
I think it's in the system. I don't think it's in this microphone, but something is a little bit wacky today with our sound system. So for the record, Representative Peter Schmidt, representing Dover Ward 1, which is Stratford 14. I'm pleased to be before you today with regard to House Bill 1474 relative to the Commission on Native American Affairs. One of the reasons I voted no on the previous bill is, well, I won't go into any great length on it. It wouldn't be appropriate, but I think we already have a commission on Native American Affairs in this state, which has been in existence for quite some time, but it also has had some problems with regard to membership and active participation in the committee and the commission, and so I think that we owe it to our indigenous fellow citizens to look at this situation with a benevolent eye, not in terms of the Great White Father, overseeing the lives and culture of our American Native brothers and sisters, but the reality is that we have an obligation as representatives to look at the commission and see whether it can be improved in its involvement. It already has a number of distinguished people who have served and are serving, and I'm not going to extemporize here on the subject because this is something that where the prime people who are giving evidence should be people who are indigenous. They don't need anybody to help them deal with their own affairs. their own culture. But the commission is intended to further the progress of indigenous people in this state, in this area, and we should strive to help them do as much as possible. So I won't take any questions because we have indigenous people here. We should listen to them.
Thank you, Representative Schmidt. Paul Pulio.
For the record, good afternoon, committee members, commission members. We, admin board. My name is Paul Pulio. I'm the Sogama for the Cossack Band of Pennacook Abenaki people located in Alton. And again, I've been a community leader since 1990. We are in support, my particular position as a tribal leader is to support 1474 for various reasons. I have not been on the commission since its inception, but I've seen its struggles since it was first codified. And the issues you see in this drafted legislation didn't come easy. The commission met on quite a few of the shortcomings and problems we'd had trying to maintain a quorum and maintaining some continuity of the board and the commission itself. And we realized that there were certain things that were originally legislated that were almost impossible to meet. And one of those criteria, there was a commission of 15 people, and several of them are state positions from the Arts Council, the Tourism, Department of Historical Resources, that type of thing. But we've always maintained about 3 vacancies for reasons that are beyond the control of our community or the commission. When you set up a 15-member commission and you have a quorum of 9, you have to cut it back in half. So you start off with 15, it's 7.5, that becomes 8, and then you need +1. So it always was 9. And it made no sense because there was never a full board ever seated, so to speak. And that process continues. During COVID, the governor wasn't making any appointments, and it just got worse throughout that whole time period. And as it stands right now, there's still 3 vacancies. And we know for a fact that the Department of Historical Resources has put in recommendations to fill these seats, but it's stopped in the governor's office. So that was one of the things that was going to be suggested, and that's what the commission did, was to bring it down to a simple majority of those members that were seated +1. So it's 50% of those the governor's appointed +1 as a quorum standard. In the hope of moving this forward, Dartmouth was always given a seat on this commission, but UNH wasn't. And that was one of the flashpoints we saw from the fact that a Native American studies, Indigenous and Native American studies curriculum was developed in UNH and is a minor now on campus. So UNH should have been included in any process with Indigenous affairs. So the proposal was to add one of those seats, which is vacant, make sure it is from the University of New Hampshire. There was also a concern to not heavily stack this with one tribal entity or another, kind of like an anti-nepotism type approach. We don't want everybody from one family. So the other thing we felt was important is to make it as robust as possible with as much representation across all the Indigenous folks that are living and resident in the state, regardless of your tribal affiliation. And it wasn't to be an Abenaki commission. It was meant to be a diverse state residency type of thing. So that was the other thing that we brought up. And the other issue was a lot of the original codification rested on federal statute, which truly does not apply to a commission that doesn't have any vetted federal authority to deal with. case in point, like child welfare cases, we've handled child welfare cases since the 1990s, and they come from all over. They don't just happen in New Hampshire. They happen all over the country when people get into a child welfare case. And we've been consulted on probably a couple of dozen since 1990. And it's really a relationship from a community to that agency that's dealing with the child welfare case. And it's not a commission issue. Just like the arts and crafts thing, we never really had an issue with arts and crafts in our particular tribe because we pushed back. We pushed back on that threshold because it's meant that we weren't competing with other Abnaki. We identified ourselves as Pennacook, right here in New Hampshire as Pennacook. We're not competing with some tribe in the West that's making silver or braided rugs. And we didn't see the same issue because we didn't have the demographics that supported any legislation that dealt with just the Arts and Crafts Act. Beyond that, it was a cleanup. And this wasn't a shallow effort. This went through Ben Wilson, which is the state SHPO, who also sits over the Commission on Native American Affairs. It was reviewed with him and found out anything that he felt needed to be done. And I know the commission brought in the AG's representative. The commission has a permanent AG representative that attends the meetings now. And these issues were brought up with the AG's representative, and they went through the wordsmithing to make sure nothing was out of order and that everything was above board as it was presented. And what you're looking at is the result of the combined effort of the commission, outside community leaders, the Department of Historical Resources, and obviously the AG's department. So with that being said, this is really just to update the commission. It's more of a maintenance issue. It does have an element in here where we can assist on providing educational resources, because us as a non-federal tribe, but we also are a federal non-profit indigenous group, we are eligible for all kinds of grants from the federal government. In fact, our tribe has gained significant amounts of federal money directly without the federal or state status. It's because they also recognize Native American nonprofits as a potential grantee for grants. So with that being in mind, we strengthen the program thing about history, culture, affairs, and developing educational materials as part of the acts that were established by the federal government. Beyond that, the rest of the issues that are federal, they were removed out of the sheer fact that the commission was never vetted for that. So with that being said, do you want to speak for the commission?
You pretty much said it all, and I'm not going to waste their time repeating. So thank you.
Thank you. We'll record your support. Any questions? Representative Goley?
Thank you, Madam Chair, and thank you for taking my question. Page 2, line 25. Can you tell me why that section is struck out?
It's not on ours.
Could you start the line because it doesn't match with any cross out on page 2?
It's the very last line. Yep.
Okay.
As
Okay,
striking
the
that
authority,
authority.
the authority for, that authority is really a legislative authority. That's not a commission authority, in all candor. See, our tribe is pursuing federal acknowledgement. To be very candid, we petitioned in the 1990s. We are on record with the federal government. We're going through the federal process, which is more in detail. It's more in depth. We have to show continued governance. We have to show genealogical relevance. We have to also show historical relevance. So I don't think this could be something vetted into the commission's authority to do.
The commission doesn't have the legal authority to recognize or deny a tribe. That's left up to the state legislature.
Yes.
So,
So
to
why
ha-
are you striking the line that says it's the legislature's responsibility?
You don't have a process, do you?
Right. So that line was struck, I was told, because New Hampshire does not have a state recognized tribe. And so the Arts and Crafts Act does not apply. The Arts and Crafts Act follows the recognition based on the tribe and where they are located. So you could be a recognized tribal member of the Cherokee and out of Oklahoma, live here in New Hampshire. You can still sell your arts and crafts as native made. You don't have to be recognized by the state of New Hampshire as Indigenous. That recognition follows you throughout wherever you happen to live.
Thank you. Any other questions? Representative Schmidt, you can't ask any questions. Representative Mangiaputi.
Thank you, Madam Chair. I'm a little confused. The previous bill was doing just that, to recognize the state commission or the tribal, relative to study the needs of Native Americans in New Hampshire.
Right.
One of the studies was to establish recognition of different tribes in New Hampshire, isn't it?
The bill actually states that that it's establishing a study group of the needs of Indigenous people of New Hampshire. It actually doesn't state that it's going to establish a recognition process. That was just a proposal that was put out by the representative.
Thank you. We don't need to discuss House Bill 1252 anymore. But thank you for. Any other questions about House Bill 1474? Representative Brown.
Madam Chair, thank you again, taking our questions. Again, on the last page, item 3 in the commission's duties has been stricken, but it seems like we did talk about that to some degree in the last bill. And why would that be a good thing to take out?
The New Hampshire Native Commission does not have the legal authority to dictate who can and cannot sell Indigenous crafts within the state. That's covered under a federal law. So the commission doesn't have any right to fulfill that call.
Okay, thank you. All right. Thank you very much.
Anyone else?
Don't see any.
All right, thank you.
All right. Turn the mic on, please.
I'm sorry, I do want to add one more thing. Franklin Pierce Law, the University of New Hampshire Law School, has now started a Title 25 law course, which is a course that teaches about Indigenous law, which includes the Arts and Crafts Act that you're all debating today. So I would highly recommend you reach out to UNH Law and speak to the professor there.
Thank you. Anyone else wish to testify on House Bill 1474? Seeing none, I will close the public hearing and open the executive session. Does someone have a motion? Representative Gould.
Madam Chair, I'd like to move interim study for this bill so that the study committee can take a look at it and see where it fits with the broader findings they come up with, especially on the issue of state recognition.
Is there a second? Seeing Representative Bailey seconds. All right. Representative Bailey, do you wish to speak to your second? Okay. Any discussion, comments, questions? Anyone else?
I'm sorry. So is the idea of the interim study to make House Bill 1474 part of the responsibility of the committee in House Bill 1252?
Representative Gould, is that your intent?
That was my thought, yes, that there's some overlapping areas here and that the study committee could take a good look at how to best come out. There's strengths in this petition for sure, but how does that fit in the broader recognition piece that everybody's had good questions about?
Can I comment on that? Okay, so I'm not convinced of that, because one of the components that I like about 1474 is that it establishes the quorum, and it establishes the limitation of one tribe for representation. So I think that those types of things are important. The only thing that concerns me is the strikeout on page 2 on lines 25 and 27. So if I would like to investigate that and confirm that before we move on to this bill, because I don't see an issue with it.
Okay. I'd like to say that I'm also not in favor of interim study because the issues of reorganizing the commission, getting its quorum fixed is, and simplifying its duties and responsibilities is very important. Mike, I don't know about the deletion since everyone admits that is a legislative responsibility. So the question is, do they need that statement in there, the definition of the commission or not?
And if the chair will allow me, I would certainly look into that unless Representative Schmidt knows the answer, because he just raised his hand.
Representative Schmidt, do you have the answer to that?
I didn't hear the question.
The question is whether the, excuse me, the deletion of the statement of legislative responsibility is because it doesn't fit in with the definition of the commission and not an attempt to redefine whose responsibility it is?
Thank you for your question. I can't give a definitive answer, but I did not ask for any of this language to be struck because I'm not setting myself up as some kind of an authority on any of this matter. This is something that the indigenous people of New Hampshire should be tasked with, and I especially think it's inappropriate to go to interim study. One of the major purposes of this bill is to improve the functionality of the commission by changing the quorum to a workable situation, which is not currently the case. So to the degree that we take away its primary function, we're neutering the very thing that needs most to be taken up and to be acted on. Thank you.
Thank you. All right, Representative Goley.
Thank you, Madam Chair. And being the one to bring up that subject of the struck out language, I too would like further clarification to make sure it is what it is. And if at all an amendment is done, I would also probably once again ask, because as you proof this, if you look on line 20, once again, OLS is just semantics with wording, again, making a change that really isn't necessary. Meeting notices of all meetings and changing that wording is totally unnecessary, and I don't know why they're doing what they're doing.
Okay. If it's the pleasure of the commission, of the committee rather, we will defer the vote on this bill until the previously scheduled executive session on the 13th. Okay, so we will postpone this while we're looking into those specific issues.
Thank you, Madam Chair. That's an excellent proposal.
All right.
Thank you.
All right. And House Bill 1174. Does someone have a motion?
Sorry, what is the
The
levy?
plumbing apprentices.
Oh, the
Madam
plum-
Chair, I have a motion.
Yes.
Expedient to legislate.
Okay, is there a
Second.
second? All right. The motion is inexpedient to legislate by Representative Gould, second by Representative Goldie. Would you like to speak to your motion?
Madam Chair, I just want to clarify. We're talking about 1335?
No. No, we haven't gotten there yet.
I apologize.
This is House Bill 1174, the plumbing apprentices we heard this
Oh,
morning.
oh. Can I withdraw my motion? I was,
I'll make a motion of ITL on House Bill
All
1174.
right, it's by Representative
Second.
Grota, seconded by Representative Goldie. Okay, thank you. Glad she admitted the confusion before she tried to explain it. So Representative Grota, you have a comment?
I do. Although I sympathize with individuals who seek apprenticeships and can't find them, there seems to be an existing way of having waivers for having more than one apprentice per plumber. And I don't see this bill as solving any issues that are apparent in New Hampshire. So I don't think that we need this bill.
Okay, Representative Goley?
Thank you, Madam Chair. And I too believe in the testimony that was given to us that this is due to the federal regulations that we follow by apprenticeship. One-on-one is what they require. But there is a waiver available that it seems like not too many people out there really know about. And listening to the individual, I don't think they've received any requests for waivers. So in my discussion afterwards with the Commissioner of Labor about getting this word out there to these organizations, that is their intent to make this known. And I think that's probably the appropriate thing to do, knowing that they're more than willing to grant the waivers out there. And I don't think having apprenticeship, increasing the number of apprentices per plumber is the problem. I think the problem is getting people to apply for apprenticeship. And I think that's the bigger problem that we need to look at and maybe address in trade schools and else.
Okay.
Thank you.
Representative Mangiaputi, you had a comment?
I do agree that there is the process that is existing that is not known to even the experienced plumber. So is there a way to make that known or available? Is it only through legislation, or is there a rulemaking one where they need to know that the federal grant is not going to be taken away by applying for the waiver? And I think that's the key point that I took away from hearing the testimony, making that waiver program available in New Hampshire can increase the pipeline, can increase even if 5 plumbers take up the waiver and they individually do 2, that's increasing the apprentice at a very grassroots level. So I just want to know if that is some way indicated, way to be indicated without the legislation.
No. We will put the comment that the waiver is available in the committee report, please, because that is important. And other than that, we are the Commissioner of Labor, who is responsible for apprenticeship programs, has said he will attempt to spread the knowledge. So pass the word to every plumber you meet. That's the only thing I can say.
Just a follow-up question for that, Madam
Yes.
Chair. So will the legislation be able to get a report, or will we get a feedback saying that went out or not, or that's not a preview?
That's not really our issue. There is a similar Senate bill that is on our way, and you can consider adding it to that if you feel it's important. Representative Lekes and then Shuett.
All right. I mean, I strongly support the goal of this bill. I'll regretfully support the ITL. Partly the issue is, the complications to federal rules. I certainly hope that Representative Goley's efforts to get the word out succeed, and that I agree that we also, whatever happens with this, we need to get more people in the apprentice program. So.
Okay, Representative Simon?
Madam Chair, I also will be supporting the ITL in its current form. I just wanted to add for the record, I did have a conversation with one of the gentlemen who gave testimony, who said that although he was aware of the apprenticeship program at the federal level, it seemed better suited for larger companies with more people, and would be pretty onerous probably for a small independent plumber in northern New Hampshire to access. So it does exist, but it might not be a great vehicle for everybody. But even still, it seems like there are steps that would have to take place in the state of New Hampshire before something like this could be brought forward, maybe more in line with something like the electrical apprenticeship program, which has access both to the federal program if they want the federal program, or to a state program, because there is a state program that does, I believe, allow them to have two apprentices at the same time. So, but not having that in place at the moment, it would be difficult to use this as a vehicle to get to the end goal.
I spoke with Senator Murphy at lunch, and he tells me that that his similar Senate bill is being amended to make the federal registration optional rather than required, which makes a lot of sense for the smaller businesses. And I think that is the proper vehicle to address it rather than having it two similar bills going through. And Representative Schuett, you had a question.
Thank you, Madam Chair. In addition to this waiver program that needs recognition, we heard during the testimony, even by the two sponsors, kept referring to rules and the different levels of apprenticeship that allow apprentices to practice more independently. And I think that that particular issue is more properly addressed in rules rather than this bill. So I will also support ITL.
Yeah. I was kind of upset that the sponsor wasn't aware that there are ways to change the rules without requiring legislation. Representative Brown, you have a question or a comment?
I just have a comment. So thank you, Madam Chair. I'm very much in support of this idea, as Representative Leck has said. And from what you just said, your discussion with the senator, I think that that helps me to make my decision for ITL. What I will add is, though, we all seem to very simply say, well, you can just go get a federal waiver. Well, who knows how complicated that is? It's hard enough to get a special exception in a small town planning board, no less to go to the federal government and get a waiver on anything. So I don't want us to sort of be cavalier about saying you could have just gotten a waiver from the federal government. It may not be such a simple thing.
Indeed, no question about that. Representative Schmidt and then Gould.
Madam Chair, well, I will also be supporting the ITL, but your remark, Representative Brown, and the fact that the federal official who was here before us said that they had not had any applications for waivers certainly does not demonstrate that it's difficult to get a waiver. It's especially difficult to get a waiver if you don't ask for one. But the point is that that we heard from the two master plumbers who've been in this profession for decades that one of the problems they have is not that they can't have more than one apprentice. The problem is they can't get enough people to apply to learn plumbing, period. One of them held up the cell phone. He said, this is what the kids today want to be involved with. They want to be involved with the not just cell phones, but modern technology. And one of them testified also that plumbing is a dirty business. You're dealing with human waste. And it's one thing if you're building a new building and putting in toilets and piping that's never seen any content. It's another thing if you're coming into my house or anybody else's house that's been in my house for over 100 years. Plumbing has been there for a long, long time, and it's still functional, but it's not nice when it has to be worked on. So that's the reality. So we're going in the right direction by ITLing the bill and trying to get people to be better informed about their options.
Okay. Any other comments? Representative Gould, yes, thank you.
Madam Chair, thank you. Now that I'm on the right bill, I agree with everything everybody said. I especially would like to see I wish that we had a way to follow up, and I liked what Representative Simon was talking about regarding the smaller businesses having difficulty dealing with the federal, but that probably goes beyond the purview of our time, but I'll support the ITL.
All right, thank you. Anyone else? Okay, the motion is inexpedient to legislate on House Bill 1174, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakes.
Yes.
Representative Bailey.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Fitzpatrick. Representative Gould,
Yes.
Representative Smith,
Yes.
Representative Mangiaputi,
Reluctant, yes.
and the chair.
Yes.
We have 15 yeas, 0 nay.
The bill passes 15-0. Is there any objection to consent?
You said the bill passes, or did I mishear you? Motion.
Yes, that was what I meant, and thank you for pointing out that I didn't say what I meant. The motion of ITL passes 15-0. Thank you. Any objection to consent? All right, seeing none, we'll put this on consent. We will, and I trust the committee will keep track of their concerns and issues so that we can deal with them in the Senate bill. All right, and I will.
I didn't mean to correct you, Madam Chair. You
But
and
you're
I,
totally correct.
we all know what you meant. The thing is that the record would be misleading if you didn't correct it, so thank you.
Exactly. All right, I will close the executive session, open the hearing on House Bill 1335. Is Representative Boulden here? Oh, there she is. Okay, yes.
I think the thing spells her name. Her name is not. Her name is spelled or not?
Can you hear me? Okay.
Yes.
For the record, I'm Amanda Bolden. I represent Hillsborough District 25 in Manchester. One of my favorite books is The Diaries of Adam and Eve by Mark Twain. Obviously, Adam and Eve didn't keep diaries, or if they did, they haven't survived today. The book is hilarious and a pretty short read. You can find it online because it's so old. Adam complains about a creature that won't stop talking. Eve complains that Adam is aloof. When they conceive a child, they debate whether it's a fish or a wild cat. Adam insists on proving it's a fish by putting it in the water. Obviously, it's a human baby. It's a good read all around and a solid example of a category of literature known as historical fiction or romantic biography. It was the night before Christmas, and all through the house, not a creature was stirring, not even a mouse. You all know that poem. It's called A Visit from St. Nicholas. The author was Clement Clark Moore, and it was published in 1823, one of my favorites. I think I have the whole thing memorized. And it was in this 1823 poem that Moore invented the reindeer and named them. But do you recall the most famous reindeer of all? Rudolph wasn't part of the Santa Claus franchise until 1939, contributed by another author. So you all know that Santa Claus is based on St. Nicholas, a Catholic saint. He was alive around 300 AD. He was of Greek descent and lived most of his life in what is now modern-day Turkey. During his lifetime, he became a Catholic bishop. He was very charitable, but to avoid embarrassing the recipients of his kindness, he left goods and necessary items for them in the cover of night. And obviously, this Catholic bishop didn't have any flying reindeer.
Yes, Representative Boulden.
Don't worry.
If you could focus a little more closely on the bill at hand.
Okay. So a book that is the origin of many of these aspects of Santa Claus was written by an author named Washington Irving. And in his life, Washington Irving also wrote other literature that was historical fiction. I know you've heard this bill a lot, Chairwoman. I don't know if Groundhog Day is another holiday, isn't it? So
we
I don't know how
celebrated
many
it
on the
this year.
committee are familiar with the issue. I just thought
Most
I'd dive
of us.
into it. Okay. So another work of historical fiction or romantic biography is called the, hold on, I have to find it on my screen. So Washington Irving wrote a biography of sorts of Christopher Columbus that in its time was criticized as an attempt to annihilate American history. And this book is the origin of the claims that Christopher Columbus believed that the world was round when everyone thought it was flat. The origin of claims that he discovered new land that had already been discovered at least 1,000 years prior by a variety of other explorers. And so much of what makes Christopher Columbus this historic character is historical fiction. by an author known for creating other works of historical fiction in a time period where it was culturally popular to consume historical fiction. But unfortunately, a couple generations later, there was strong anti-Italian sentiment and anti-immigrant sentiment in the U.S. as it persists today toward other groups. And in that vein, those folks who grew up with historical literature and I assume didn't understand what they were reading was fiction, invented a holiday to help with the public perception of Italians. So in reality, Christopher Columbus thought that the world was pear-shaped in a time when everyone knew that it was round and you could buy globes for sale. And he was so adamant that it was pear-shaped because he was looking for a shorter trip to India for spices. And Native Americans are referred to still today as Indians because to the day he died, Christopher Columbus was convinced he had found a shorter route to India through the curve and the pear shape of the planet. So instead of a flat earther, he's more of a pear earther. And he never touched American soil. The closest he got was Puerto Rico, which was only made part of this country years after Columbus Day was instituted. And when he was on that land and he encountered natives, he rode them for transportation. If he felt that they were dishonest, he would cut off their hands. He sent them to find gold for him in the rivers. And if they didn't produce enough, he'd kill them. And in the time that he was on a particular piece of land, he reduced a population from 250,000 down to a couple hundred people. And in his time, his activities were regarded as criminal. Eventually, the Spanish monarch sent a ship to collect him, and he spent a substantial amount of time in prison in Spain for his activities in the New World in India. So the fact that today in 2024, there are still people who wholeheartedly believe these fictional aspects of this character, a character not unlike Santa Claus, not unlike the Diaries of Adam and Eve, where that is not who they were. It's just how this author has represented them. The fact that these myths survive today, I think really underscores the fact that the contemporary critic was correct when they reviewed Washington Irving's biography of Columbus and said that it was an attempt to annihilate the history of America.
So about the bill.
Italy's Columbus Day. That's all.
Thank you.
It's a good, I like history, so I like exploring it. And it should be noted, there are other aspects, things that we traditionally believe that are not factual. Paul Revere didn't ever say the British are coming.
Yes, thank you.
Because he was British. He would have said the regulars are coming.
Thank you. Are there any questions? Seeing none. Representative Porcelli?
Afternoon, everyone. Thank you for allowing me to testify. For the record, my name is Susan M. Porcelli. I am a representative from Rockingham, District 19, Hampton Falls, and Kensington. I am in strong opposition to this bill. As a proud Italian American, I celebrate the contributions of Italian Americans that built this country. My grandparents emigrated legally from Italy in the turn of the at the beginning of the 1900s. My grandparents worked tirelessly. One grandparent helped build the Holland Tunnel, and they worked very hard, and they were very proud people. During World War II, the town I grew up in the residents would have starved if it wasn't for my grandparents and the skills that they brought with gardening and being able to raise livestock and feed half the town during the Depression and the early part of the war. My parents gave me a work ethic and understood the Italian American experience. We worked very hard. Growing up and into my early career in business, I experienced prejudice, discrimination, and other horrible things. We were discriminated against in housing. I was discriminated against in the workplace. I still remember to this day, as a young woman in her 20s, when I was trying to climb the corporate ladder and I had all of the credentials that everyone else had, and my manager said to me, "We're not promoting you because you're only an Italian girl." To this day, that still resonates with me. Italian Americans have contributed to this country. However, discrimination still exists. And I'm sure the other testimony will be of the others will be able to tell you about the atrocities that Italian Americans suffered through in the late 1800s, the worst lynching of a group of people in American history. Columbus Day, to me, represents a day to honor the great contributions of Italian Americans that built this country, and not to honor one specific person. Italian Americans are a proud people, a warm people, a loving people, and the holiday is in that spirit. Italian Americans built this country, and we want to be able to recognize their contributions on this one day. It's not about the man, it's about the contributions of this great, warm, loving group of people and other immigrants that we celebrate together and understand that America is the greatest melting pot and best country in the world. That's why so many Italian Americans wanted to emigrate here. So I strongly oppose this bill. Any questions?
Thank you. I think you've made your, oh, Representative Gould has a question.
I'm just wondering how that Italian girl got where she is today.
I kept working. I outworked everyone. I proved myself every single day, and I still do that to this day. And it's because of the work ethic that my parents inculcated in me.
Thank you. This looks like it's going to be a long hearing, so let's try to keep the questions focused. Representative D'Alessandro, excuse me, Senator D'Alessandro, my mistake.
Thank you, Madam Chairman. For the record, I'm Senator Lou D'Alessandro. I represent District 20, Manchester Wards 2, 3, 4, 10, 11, and 12. And I am honored to come before you today in opposition to this piece of legislation. I am an Italian American. My grandparents immigrated to this country looking for a better life. They were successful. And in this context, they loved America. They were sled length in support of the American dream, which all of us share, and gave to this country far exceeded what they received. The honoring of Italian Americans is something that the President of the United States created Columbus Day in honor of a group of Italians who were unceremoniously hung in Louisiana. They were accused of a crime. They were all acquitted. They were taken out of, they weren't released from jail. They were taken out of their cells and they were hanged. No one has ever been accused of the crime. No one has ever been convicted of the crime. But this honor Columbus Day was to honor these Italian Americans and to give response to discrimination that existed against these Italian Americans. And that's not to say that others are not discriminated against, because they are. But something like this manifests that the country understands that we're all in this together. Italian Americans, Greek Americans, Irish Americans, we're all in this together. And this day, Columbus Day, we celebrate ethnicity, but we celebrate for everyone. We can never lose sight of that fact. I have been in these legislative halls for the last 50 years. I've seen discrimination against myself, and I've lived with it. I've also seen the wonderful companionship, the wonderful consistency in getting things done together, which makes a lot of sense to me. And indeed, we should continue that. And discrimination against any ethnic group has to be put aside, thrown away. Maintaining Columbus Day is important. It's important because we recognize the contribution of Italian Americans. But in essence, we represent the contribution of every ethnic group to this country. This country is built upon bringing people together. And we've got to do more of that. We've got to do more of that as we speak today. You know, the country's in disarray. We've got to bring the country back to where it was. So I thank all of you for your attention. I appreciate the opportunity to appear before you. And indeed, I'll ask any or address any question that you might have. I apologize that I'm going to have to leave because we're in session across the street, and we're trying to bring good things to New Hampshire. So thank all of you for your
Thank you,
service.
Senator.
A great American group. Thank you.
Okay. Thank you. Representative Goldie.
Thank you, Madam Chair, and thank you, Senator, for taking my question. I agree with your remarks. One quick question. This bill strikes Columbus Day as a state holiday. What would happen to those state employee contracts that recognize that in the contract as a state holiday?
That's a very good question. Thank you, Representative Goley. It's a negotiated item. It will remain as part of the negotiations, and they'll renegotiate as we move forward. But it's there, and please the Lord, it's going to stay there, and it will be not only Columbus Day, but it will be a celebration of ethnicity and the pride that we all share in our ethnic heritage.
Thank you. Other questions? Seeing none?
Thank you, ma'am, so
Okay.
much.
All right. And we've got 8 people with Italian family names who wish to speak against the bill, all of them wanting 5 minutes. So I hope you will be respectful of our time. Francesca Marconi. I hope so.
Good afternoon. I was not going to, Francesca Marconi from Portsmouth, New Hampshire. I was not going to speak today, but I was compelled after hearing others speak. My grandparents emigrated to America in 1911. My dad was a World War II decorated veteran who always told us kids the greatest gift that his parents ever gave him was being born in America. And we were to never forget that. Our Italian culture is being ripped apart, what I believe is a knee-jerk reaction of legislative bodies nationwide. Let us celebrate our heritage, share our culture with other peoples. Let us be recognized alongside everyone else, as Senator Lou D'Alessandro said. Columbus Day is a symbol that we use to celebrate our heritage and our contributions to America. I strongly oppose this bill, and I say, let it be. Leave it. Thank you.
Thank you.
Questions?
Don't see any. Thomas Rogie.
Hello, and thank you for giving me the opportunity to speak in front of you. My name is Thomas Rossi, and I'm a relatively recent resident of New Hampshire, having lived here for about 10 years. My family also immigrated to this country in the late 1800s and early 1900s, and have fought for this country in World War II, the Korean War, the Vietnam War, and have made many contributions both in terms of helping to build the country, to build major structures, and do labor in the New York area, as well as New Jersey, and also in the scientific community. It has been their dream and my family's dream ever since coming to these shores to pursue the American dream, and with hard work and perseverance and passing on that desire from generation to generation, they made that dream a reality for me, and I hope to make it a reality for my children. As far as Columbus Day is concerned, I recognize and acknowledge that there's a great deal of mythology about historic events that occurred and were taught to us the way they were in the 1960s and that era. However, Columbus Day to me is more of a cultural significance than a historical recognition of Christopher Columbus. It's much more some recognition of the contributions that people like those in my family and many other Italian Americans, such as those who helped to build Portsmouth and resided in the north end of Portsmouth for many years until urban renewal decided to really devastate the north end where most of the Italian Americans lived. They were erased from that community, dispersed, their housing was destroyed, and today it's simply an area where large developers come in and profit off of those lands. So I don't want to see the Italian American community further erased from New Hampshire by eliminating the recognition of a very culturally significant day for my people. Thank you very much.
Thank you, and I apologize for mangling your name.
That's no problem at all.
Okay, I don't see any questions. Gino Marconi? Turn your microphone on, please, Mr. Marconi. Thank you.
It was already on.
Ah.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Gino Marconi, and I would like to preface that by saying I am here today as a private citizen. Some of you I've sat before in other legislative hearings. What has been said is true by everyone who spoke before me. This is personal. We are a culture, but part of that culture personally is my grandmother came over. She was with child. When the child was born, they named him Columbus John Marconi because he was on the boat. But the John part actually was for Giovanni Gabato, who English call him John Cabot. He was an Italian navigator, and as a merchant mariner, I know a little bit about that. He was an Italian explorer who is credited with discovering what we now know today as Canada. So there's a lot of personal history here, a lot of culture, and I will leave you with one last thing, and that is my good friend Senator D'Alessandro a few months ago wrote a great op-ed in the newspaper talking about all the accomplishments and contributions that the Italian community has made to this state and to this country. It was well worth the read. So I won't take any more time. There are other speakers. Thank you.
Thank you. Okay, Elise Gallo.
Short one copy, so I'll leave this when I leave.
Thank you.
My name is Elise Gallo. I am an American citizen of 100% Italian descent, and I strongly oppose New Hampshire State House Bill 1335, along with any similar veiled attempts to discontinue our state's celebration of Columbus Day. In fact, I'm urging the legislature to table this bill indefinitely so we never have to come here again to convince you of the importance of the one and only American holiday that honors the Italian culture and my native people's contributions to the state and to the country at large. I've lived in New Hampshire for 40 years, raised my 2 children in Brentwood, and served as an elected officer in that community from 2003 to 2016. I am now a resident of Portsmouth in Ward 5. October last year, I took the Portsmouth City Council to task for their shameful abolishment of Columbus Day and replacement of it with Indigenous Peoples Day at the request of a group of misinformed middle school children. As if it makes any sense to replace the Americans of Italian descent with Americans of Native Indian descent. Of course it doesn't make sense, and literally pits one cultural group against another. All the peoples of our nation have contributed to its rich fiber and deserve recognition. I don't have to educate this honorable body as to the history of Columbus Day. It has little to do with the one mercenary merchant mariner and everything to do with ending discrimination of Italians after a brutal massacre, lynchings, by the way, of 11 innocent Italian immigrants in New Orleans in 1891. Though no doubt President Harrison, when establishing that first Columbus Day celebration in 1892, was trying to encourage the Italian vote, the effect of the holiday was a shot in the arm to immigrants, just like my great-grandfather. Having hidden his given name, Gaetano, and going by Thomas to try and pass as American, there was finally a feeling of acceptance, and that maybe an end was in sight to blatant bigotry, prejudice, and slurs. All he wanted was to be seen as an American and to raise his family as honorable American citizens. A plasterer, he lived with extended family, 24 of them, in an Italian ghetto in Harlem, New York, sharing one toilet while doing backbreaking work of constructing stately public buildings of New York City, all of which stand today. I just thank God he isn't here to see the statues of Columbus, dozens of them, all over the country, funded by poor people like him, torn to the ground because of ignorance and continuing anti-Italian sentiment. And to this I say vergogna, which means shame in Italian. A sponsorship of this bill in my beloved state means only one thing, that discrimination against Americans of Italian descent is still alive and well in 2024. Please put an end to this once and for all. Table New Hampshire House Bill 1335 indefinitely. But I implore you, do more than that. This year you legislated curricula, cursive and multiplication tables. It's sad that we need laws to enforce common sense, yet I applaud you for taking necessary steps when common sense is nowhere to be found. Here's a perfect opportunity to legislate some history, and I don't mean anti-Columbus propaganda that students are being fed by uninformed teachers. Require that our public educators not only celebrate Columbus Day on the second Monday of October, but teach children the facts of origin and spend time honoring the contributions of Italian immigrants in building this nation. In closing, I ask you, honor Italian immigrants, their immense contributions and cultural richness by killing this misguided bill. Honor my great-grandfather and all like him, and please understand that they themselves would never in a million years felt they were owed a day of celebration or reparations or statues. Yet safeguard this one day for us because it's the right thing to do, and I think you know it. Thank you.
Thank you for your testimony. Di Brandano? Di Brandano? Ah, Al. Forgive me. Look like a D.
Thank you, Madam Chair, and thank you, committee. My name is Al Brandano. I'm representing myself. I'm also a part of the group of Friends of Italian Americans here in New Hampshire. And my testimony is in front of you. It's about 5 minutes long. I'm not going to do that to you. I'm just going to paraphrase if you don't mind. It's very interesting that the woman earlier today the maker opened up a history. And it's kind of fitting for a minute, if you'll give me just 30 seconds. It's about the courage of Columbus. And I want us all, if I can take you on a little journey, if you'll open your mind on this adventure. It's August 3rd, 1492, nearly 500 years ago. Captain Columbus from Genoa, Italy, and I would like to invite you and join you on our first voyage of a perilous and arduous adventure. This mission was to discover a new passage to perhaps India or China for spices and to trade. Aboard the ship, fear, stress is a constant companion for us. 86 crew members spread across 3 tiny ships, not designed for ocean voyage. Each tiny ship measured just between 50 and 70 feet from bow to stern. In today's equivalent, the size of a trailer truck. We endured cramped quarters, limited hygiene facilities, scurvy, dysentery, constant exposure to the elements. The prospect of falling off the edge of the earth or encountering mythical sea creatures or facing hostile people was very real to us. On October 12, 1492, 35 days later, land ho, I took the liberty of reading the captain's log of Columbus on his first voyage. Of course, it was translated. I don't speak Italian that well. But one of the most things that struck me, October 12, 35 days later, arriving in what is today Cuba, their first meeting, the inhabitants, the following is the exact words of Columbus in his logbook for the first voyage and discovery of the inhabitants. That they might feel great friendship for us, he says, and because I knew they were a people who would be better be freed and converted to our holy faith by love rather than by force. That's his words. So if we want to bring up history, that's history. The part I'll end with here is who is behind really a coordinated and sinister scheme to attack Columbus and Columbus Day. The attack on Columbus is based on distortions of his person and activities that can be traced to the earliest accounts of de las Casas, the governorship of West Indies, who wrote exceedingly favorable about Columbus. De la Casa was writing about the atrocities of Francisco de Bordella, who ousted Columbus from office by bringing false claims against him, which Columbus defeated in court. Not only did the crown find the claims patently false and dismiss them, but they put their money where their mouth was and funded the fourth voyage. This was followed by 1921 by Ku Klux Klan, along with addition of 2 more modern sources. The first, a book by Howard Zinn, The People's History of the United States. Because besides Columbus, Zinn is a Marxist socialist. He has also condemned Abraham Lincoln, America, and its allies in World War II. This book has been believed by many people and is affiliated in our schools, unjustly influencing our young people. Second, the attack on Columbus Day by Victoria Vesquez from the Takedown of Columbus Group, who was determined to remove statues and other positive presentations of Columbus. The following is Robert Patron's response to Vesquez. Even by today's impossible utopian standards, along with the passage of Columbus Day as a federal holiday nearly 132 years ago, Columbus was without doubt the greatest hero of the 15th and 16th centuries. He was a capitalist in the age of empires, and what he did began the downfall of imperialism. He was a scientist in the age of superstition. He was a civil rights activist in the age of oppression, and he was a pacifist in the age of warmongering. Thus, Columbus was an icon and a paragon, a model of excellence. In closing, New Hampshire legislators recognized the fact in 1929 in RSA Section 2881 adopted Columbus Day as a state holiday. So why now would you vote to cancel Columbus Day and erase our history and cancel our immigrant sacrifices and memories? Now, especially in a time when the noble goals of pursuing society's mantra of diversity, equity, inclusion, justice, and coexistence are so popular. Please vote against HB 1335.
Thank you. Frank Ferrera, Representative Brown, will you answer a question, sir?
Yes, please.
Representative Brown?
Thank you, Madam Chair. Following up on what you said, and I think for following up on what you said, would it be accurate to say that yes, Columbus was imprisoned, however, he was then transported back to Spain and exonerated?
That is correct.
Thank you.
Okay. Frank Ferrero?
Thank you, Madam Chair. And I'll summarize the more lengthy written testimony that I've submitted. Good afternoon. My name is Frank Ferrero, and I live in Northampton. I'm here today as a private citizen and resident of New Hampshire, testifying against passage of HB 1335. Like what you've heard today, like millions of poor immigrants from southern Italy, my father's parents immigrated to America at the turn of the 20th century. My grandparents landed on Ellis Island with $2 in their pockets and initially lived with my grandfather's brother in the Little Italy section of New York City. Through their hard work, they built a life for themselves and their family of 9 children. Allow me to provide a little context why I oppose 1335. Contrary to what we may have been taught, slavery didn't end in this country in 1865. Slavery of Italian immigrants continued into the early 20th century through a system called the Padrone system. Padrone means boss or master. Newspapers carried stories about Italian slavery from the late 1800s into the first decade of the 20th century. The Padrone Act of 1874 was passed by Congress to end Italian slavery in America. Nevertheless, the Padrone system continued into the 20th century in places like Boston's North End. In more than 40 occasions in the late 19th century and early 20th century, lynch mobs took the law into their own hands against Italian immigrants. The most outrageous of these lynchings was the 1891 lynching of 11 innocent Italians in New Orleans. That massacre almost led us into war with Italy, and it moved President Harrison to declare the first national Columbus Day holiday on the 400th anniversary of Columbus's landing in America. At the outbreak of World War II, over 600,000 Italian immigrants suffered curfews, confiscations, and mass surveillance swept up in a wave of racism and persecution during World War II. In the 1960s and 70s, when the federal government offered cities money for urban renewal, Portsmouth jumped at the opportunity. They chose the mostly Italian North End for renewal and began demolition of hundreds of homes, sometimes only given days' notice for people to vacate their houses. The once cohesive Italian community was dispersed all over the seacoast. Homes were destroyed, even though there were no plans for what would replace them. Today, 60 years after that event, there's still one lot that remains vacant from urban renewal in Portsmouth. I say all this not to try to equate what happened to Italian immigrants through the Padrone system with the disgrace and horrors of slavery of Africans in America, nor to imply that other immigrants have not been treated poorly, but to illustrate that naming Columbus Day as a holiday was an effort to help heal the racism, the lynchings, the discrimination, and other mistreatment of Italian immigrants and their descendants have endured. I won't go into a long testimony on Columbus the man. Suffice it to say that much of what is taught today and what you will hear and read through the testimony on this bill about Columbus is based upon writers who had an agenda and used bits and pieces of primary sources mixed together out of context and meaning. Old age shakes. I'll get there, excuse me. Here we go. Columbus wasn't a saint, but he was a good man and an explorer. And despite what some people say, he treated the native people fairly and with compassion. And I appreciate your question, Representative Brown. Columbus never spent time in a prison. He was immediately released by the Queen and King of Spain upon reaching Spain. Columbus Day holiday was declared to honor people who were subject to violence, discrimination, lynching, slavery, and having their lives torn apart. Columbus Day is a celebration of what it means to be a descendant of Italian immigrants. Like most first and second generation Americans of Italian descent, I'm proud of my Italian heritage. Passage of HB 1335 would be yet another insult to the 150,000 New Hampshire residents of Italian descent. And I urge you to find the bill inexpedient to legislate. Thank you.
Thank you. Paul Montrone.
Thank you all for the privilege of testifying against HB 1335. My name is Paul Montrone. I'm a proud citizen of New Hampshire for 50 years, and I very much appreciate the service that all you give to our state. To be frank, I was surprised to see the subject of eliminating Columbus Day come up to our legislators again, since it has been defeated in the past, and to my knowledge, there has been no new developments on this subject. I certainly support the testimony of others that you've heard against this discrimination proposal, and will not repeat their information, but I would like to just bring out a few other relevant additions. First is a photograph which is being passed out. It is from 1938. It is my grandfather, an Italian immigrant, and other Italian immigrants sitting on the steps of a church in Scranton, Pennsylvania, where he and his family lived. Please, when you look at the photograph, note what these immigrants are holding in their hands. It is the American flag. Notwithstanding the current by the way, I should point out, because a few others brought out the World War II, I lost 2 uncles in World War II. Notwithstanding the current misinformation on the character of Christopher Columbus, it is clear evidence that Columbus Day was not a celebration of Columbus himself as an idol, but an expression of, against the expression to protect these poor immigrants. And it was an expression of their gratitude for being allowed to come to America and pursue the American dream. The Columbus Day holiday continues to be celebrated in gratitude to our immigrants, by our immigrants for being part of America, and America's thanks to them for their contributions to our great nation. As I look around this room, presumably virtually all of you are the descendants of immigrants from some nation. Columbus Day is the only holiday honoring our immigrants, and I'm at a loss to understand the reason for potentially eliminating it as a holiday after 130 years as a national holiday and almost 100 years as a holiday in the state of New Hampshire. If you could rationalize justifying deleting it because it's named after Columbus, perhaps then we should eliminate the District of Columbia, Columbia University, the Knights of Columbus, Columbus, Ohio, and the 20 cities, cities named after him in 20 other states, and other uses of his name throughout our great nation. Then we should perhaps consider deleting other holidays. For example, President's Day. Presidents had slaves. The 4th of July celebrates colonialization. Christmas violates the separation of church and state. So in brief, out of respect for the best use of your time in service to our citizens, which I deeply appreciate, as I mentioned, I suggest that you delete this attack on Columbus Day once and for all. Thank you for your attention and opportunity to testify.
Thank you. Unfortunately, we can't act beyond the end of this year.
I understand.
Lou Gargiulo.
Good afternoon, Madam Chairman and committee members. My name is Lou Gargiulo, and I reside in Hampton Falls, New Hampshire, where I serve as a selectman, and I'm also a former member of the New Hampshire General Court. My newest duty is I'm one of the overseers and incorporating members of the Friends of Italian Americans. The Friends of Italian Americans was formed last year, and in a short period of time, we have over 200 members. And with the growth that's taking place, we expect to have a couple of thousand in the next year. I am here representing myself today and our members who stand with me in opposition of HB 1335. I'll try to be as brief as possible. My father, Luigi Gargiulo, was born outside of Naples, Italy, over 100 years ago. He fought with American troops in the liberation of Italy in World War II. Immediately following the war, he immigrated to the United States. As a person growing up in Italy during the Depression and the war, my father longed to follow the steps of another Italian, Christopher Columbus, and come to the New World. Although Christopher Columbus did not discover North America, he was the founder, really, of the Western Hemisphere. His exploration and knowledge gained was critical in the development of this part of the world. We are not here today to debate Christopher Columbus. We are here today to explain that millions of Italian Americans and other groups who immigrated from faraway places view Columbus Day as a day set aside to remember and honor those who came before us and to build our country to where it is today. They were the construction workers, the lawyers, the doctors, the nurses, the waiters, the scientists, the teachers, store owners, soldiers, and yes, politicians, those who sat in hallowed halls of Congress and also in the New Hampshire House. Stripping away Columbus Day is an insult to millions and millions of Americans who immigrated here and who are family of those who did. My father came here because he believed in the American dream. My father lived the American dream. I, as a son, have also lived the American dream. I built a business from nothing and now employ over 150 New Hampshire citizens. My children and my grandchildren are living the American dream. My daughter, Colleen, is an Army officer serving, and she asked me when I told her I was testifying today to tell her she would love to have been here and to tell you how she feels about this. Part of the dream is to honor and cherish our history, and Columbus Day is part of our history. I respectfully ask you to find this bill 1335 inexpedient to legislate, and let's move on with more important things. Thank you very much, and have a great day.
Thank you. Is there anyone else who wishes to testify on House Bill 1335? All right, seeing none, I'll close the public hearing and go into executive session. Representative Simon?
Thank you, Madam Chair. I'd like to move inexpedient to legislate on H Bill
I'll second
1335.
Oh,
All right, Representative Simon moves inexpedient to legislate. Representative Grota seconds. Do you wish to speak to your motion?
Yes, thank you, Madam Chair. Been wading into difficult subjects lately, so I might as well do this one as well. I have, I guess, 2 points that I'd like to make. One, I agree with a lot of the testimony today that the present iteration of history on Columbus is inaccurate. My own personal study demonstrates him to be a man of courage, a good man as a general rule, and was certainly exonerated from his crimes. But the main portion, main reason why I move inexpedient to legislate on this bill is what a lot of the testimony today kind of spoke to, which is that America was established to be an experiment of sorts, and most of us are immigrants, though not all of us. I mean, there are some of us who are native, but many of us were. But it is the one place that was established with the idea that people from every nation could come and be free. And I feel like today, the attitude towards that is that should be somehow easy, that that's within the nature of human beings to do that sort of thing. And it isn't. In fact, it's very much the opposite of our nature to be inclusive and to welcome and to be able to work together through our differences and establish something that is worthwhile. And Columbus Day is one of the days that celebrates that. I would also add into that Martin Luther King Jr. Day, which allegedly has some problems in his own history, but symbolizes that with the Black community and also with St. Patrick's Day. I know people celebrate things for different reasons, but with the Irish as well. All symbolizing our struggle to integrate together and to bring our different ideas and our different traditions that sometimes rub the wrong way with other people who have already been established, but that we would be able to come together as one people group. And so I see those as kind of a triad of our aspirations, and to continue to celebrate them would be to continue to aspire in that way. And so for those reasons, I move inexpedient to legislate on this bill and hope my colleagues will join me.
Representative Groda?
Thank you, Madam Chair. This type of bill or a bill similar to this has come before us many times. And I think that if there had been some sort of change of information or sentiment, we might reconsider, but I think I agree with the motion, and I'm sure that the House will support that as well. So that's all I have to say. Thank you.
All right, Representative Smith.
Madam Chair, I don't go along with this. Well, I do go along with the bill. I understand about the Italians and what they have done for America, and I agree with everything you said, Representative Simon. However, couldn't we change the name of the bill? Get Columbus out of it. Change the name of the bill and call it an Italian.
Okay, Representative Groda would like to respond to that.
Okay, that's fine.
So last year on the House of the Floor, I specifically presented that floor amendment, and it was defeated by the House. So the House does not wish to change the name of Columbus Day to Italian Heritage Day.
In that case, then, okay.
Gould?
Madam Chair, and thank you, Representative Simon, for a beautiful bill. Though I was mistaken in my earlier motion on what bill we were on, my intention was to move ITL on 13.5, and I am a proud Abenaki woman. My first husband was Ronnie Scaparati from the North End of Boston. My daughter is pursuing her Italian citizenship, though she's already a citizen of the Abenaki, the Nalhegan Band of the Coasac Abenaki Nation, and of course a citizen of the United States. I think that it is very sad that this whole discussion has pitted Native American people against Italian people. We are all people, and we have no reason to hate one another, and we have no reason for hard feelings toward one another. And we have lots of reasons, not just how much I love my ex-husband or how much I love my daughter, but we have lots of reasons to not let a small faction of our society turn us against one another. So I fully support ITL on this bill.
Thank you, Madam Chair. Most of the testimony and what Lou Gargiulo mentioned, that this is really not about Columbus the person. I appreciate all of that. I would like to address, however, because it was brought up in the initial presentation of the bill, a couple of comments that I'd like to address. Although I have never read Washington Irving's biography of Christopher Columbus, done some reading, as Representative Simon has said. So I want to I want to clarify what I think were several points made in the original presentation. When Columbus did come to the New World, there was a huge decrease in the population, not because Columbus and others went out and slaughtered everyone. It was mainly because disease that was brought to this part of the world by the Europeans, and there was also an issue where Columbus was defending some of the tribes that were being subjected to cannibalism by other tribes. That's one of them. So there was a reduction in population, but an inference that that Columbus eliminated all those people, I think, in my estimation, it is accurate. We had talked about the prison sentence and the exoneration. Also, certainly, we know now that there were others that had discovered this continent, but at that time, and celebrating the fact that Columbus was a brave person and discovered a continent that no one knew was here, at the time was very accurate. The Europeans at that time did not know that there was a continent here. So to say that everyone kind of knew this already and Columbus was not a brave mariner for that, I think is inaccurate as well. And I think that's all I had. The other pieces have been touched on. So thank you, Madam Chair.
Okay. All right. I'd like to make 2 points. And the first is that we keep tearing down our heroes because they aren't perfect. And that's something that it's our fault for expecting the people who accomplish things to be perfect. If they're human, they're not going to be perfect. And the other thing is that regardless of the fact that other people had visited this continent, from the Vikings to St. Columban, was it St. Brendan? St. Brendan, I think. It was Columbus and his voyages that started the integration of the Western Hemisphere with the Eastern Hemisphere, and that changed the whole world forever. And I think we need to recognize that regardless of any issues of the person or people involved. So I am definitely going to be supporting the ITL. Anyone else? All right, we've all speechified. The motion is inexpedient to legislate by Representative Simon, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis. Yes. Representative Bailey.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett. Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Smith.
No.
Representative Mangiaputi.
Yes.
And the chair.
Yes.
14 yea, 1 nay.
All right. The motion of ITL passes 14-1. Is there any objection to consent? Representative Schmidt objects to consent, so we'll put this on the regular calendar.
Wish to speak to my objection to consent. This is a perennial bill which has the very unfortunate effect of being seen as anti-Italian. It's clearly anti-Columbus for reasons which we can argue and dispute with regard to every aspect of his character, his accomplishments, and so forth. It certainly is an anti-Columbus bill, but it is inextricably seen by Italian Americans as an anti-Italian American bill, denigrating their great accomplishments and contributions to this country. That is extremely unfortunate because I'm sure that none of us think that there's any merit whatsoever in the idea of Italian Americans not having made magnificent contributions not only to world culture but to this country across the board. If if I had to measure how much spaghetti I've eaten, I'm certainly more than 100% Italian just in the last year. But in any case, the reality is that this bill, and that's one of the reasons that it should be on the regular calendar, that the whole House should have an opportunity to vote no on the idea of that this House is in any way a party to the idea that Italian Americans have not made enormous contributions on the one hand, but also suffered greatly, as has virtually every other non-indigenous population, and they have their own suffering to be cognizant of. So I think the whole House should vote no on this.
Thank you. That's easy enough. All right. I think we've finished our executive session and we are done for the day. And I will see you all tomorrow in session, and next week we're on vacation.
For these, I don't want to throw them out.